We're back for another day of hearing in EO 2022-0040 and EO 2022-0193. We'll begin today with a witness for liberty, Mr. Masindi.
Yes, thank you, Judge. We call Mike Mazandi to the stand.
And I apologize, I heard your name, but I still mispronounced it, so.
It's okay. I've been getting it all my life there. Mazandi.
Okay,
Yeah.
Mazandi it is. If you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Thank you. If you will please state your full name.
Full name is Michael Mazandi.
And this is not normally part of our direct questioning, but I would note for you, we talked about how there'd be a court reporter right in front of you. There is not a court reporter here, but we are being recorded and they'll transcribe it, so it's still important that you speak slowly and clearly.
Probably more so than normally.
Yes, yes.
You can have a seat.
Oh, perfect.
Yeah. So,
Thank you, Your Honor.
by whom are you employed and in what capacity?
Liberty Utilities Canada Corp. As Director of Treasury.
And in your role as Director of Treasury, does that include doing work also for the Empire District Electric Company?
That's correct.
Did you prepare pre-filed rebuttal testimony that has been marked Exhibit 15?
I did.
Do you have any changes to that testimony?
I don't.
If I asked you those same questions today, would your answers be substantially the same?
That's correct.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
I would move for the admission of Exhibit 15 and tender the witness for cross-examination.
All right, Exhibit 15 has been offered. Any objections to its receipt? Hearing none, it will be received. And for cross-examination, we will begin with, MECG's not here today also for staff.
Thank you, Your Honor. Kurt Stokes on behalf of staff this morning. Mr. Mazandi, you say in your rebuttal, Exhibit 15, that it is important that bonds provide quantifiable net present value benefits to customers compared to traditional methods for recovering costs. Is that?
That's correct.
And you say that net present value savings is a threshold matter, correct?
I'm sorry, can you repeat that?
You state that net present value savings is a threshold matter?
I'm not sure I said that in the testimony. Can you point to where that
yes,
says
if you
threshold
turn
matter?
to Exhibit 15, page 2, line 6.
Okay, yes, that's correct.
Liberty is proposing that certifications be filed with the Commission in connection with an issuance advice letter here, correct?
That's correct.
And the certifications would be filed, one would be filed by Liberty,
That's correct.
and then another one would be filed by the underwriter.
That's correct.
Would you agree that those certifications should include a statement that the bonds as structured provide quantifiable net present value benefits to customers compared to traditional methods for recovering costs?
That's correct. That is one of the statutory requirements.
And would you agree that the certifications should also include calculations used to arrive at that certification?
I would agree.
And would you agree that the certifications should state any assumptions used in that calculation?
Correct.
And then would you also agree that the certifications should state that the bonds as structured result in the lowest securitized charges consistent with market conditions at the time the bonds are priced?
That's correct. That's consistent with my testimony, rebuttal testimony.
Okay. Now, you also state in your rebuttal testimony that marketing and pricing of bonds is, quote, not fundamentally different from traditional debt securities issued by Liberty. Is that correct?
That's correct.
But for traditional debt securities, Liberty owes the obligation on those debts, correct?
That's correct, if Liberty is an issuer.
But under securitization, under this statute, the ratepayers would owe that obligation, right?
That's correct.
And Liberty would not owe that obligation.
Correct.
And that's a difference.
That is a difference.
Okay. You also state in your rebuttal that the fundamental purpose of securitization of the cost for Winter Storm Uri and Asbury is to benefit customers through reduced customer rate impacts. Is that right?
Correct.
You don't state that the fundamental purpose is to include costs that couldn't otherwise be included under traditional rates.
Can you clarify that question?
Yeah, you don't say in your rebuttal that the fundamental purpose of securitization is to include Liberty's recovery of costs that would not be traditionally recovered under traditional rate making.
I don't state that, no.
Okay. You state that the SEC and rating agency process are separate from the marketing and pricing processes, correct?
Correct.
And the statute only addresses the marketing process, right? As far as the like if the commission were to designate a staff representative.
No, I believe it's the entire process there.
Okay.
All facets of the issuance. The designated person would be involved.
Okay. Have you reviewed the proposed financing order attached to the testimony of Ms. Niehaus?
I have.
Now, in your surrebuttal testimony, you say that staff representative and financial advisors would be invited to join any conference call,
Correct.
but that financing order doesn't mention any conference calls.
I mean, I don't think it gets into that detail in the financing order.
You also don't say that you would, staff representative or financial advisor would be invited to all calls.
I mean, I don't think that, I think it says that the designated representative would be involved in the process from start to finish.
I'm just trying to get into the specifics of what that means. You don't say that there would be any in-person meetings?
I mean, during today's time, I think everything is really virtually, given where everyone is located,
But if there were an in-person meeting, there's nothing in your testimony about financial advisors and staff representatives being invited to those in-person meetings.
there is not.
Yeah. And your surrebuttal also mentions staff representatives and designated and financial advisors asking questions,
Correct.
but there's nothing in the financing order or your testimony that requires those questions to be answered.
I believe I do state in my testimony that, my surrebuttal testimony, that any questions that are answered will be taken and with advisement and responded to.
Okay. Now, you also say that the staff representative and financial advisor can provide suggestions,
Correct.
but there's no way to resolve concerns about those suggestions getting ignored or disregarded, right?
I think it's a collaborative effort.
But there's no way to resolve those concerns. If there is a difference of opinion, there's no way to resolve.
I think any differences would be addressed and discussed with the designated representative to ensure that they are okay with the approach if there are differences.
If there were a difference, though, under Liberty's proposal, the only way to resolve it would be a recommendation to reject the issuance advice letter, correct?
I mean, I don't think we would, hopefully we wouldn't come to that, and I think we're all working towards the same goal of saving customers money and getting the lowest cost issuance. So I would hope we wouldn't come to that.
Yeah, because rejection of that issuance advice letter would be catastrophic to the deal, correct?
It would be.
Yeah. Now, you say you hope it wouldn't come to that, but your proposal doesn't have any dispute resolution process before that issuance advice letter to resolve disputes about what the marketing and pricing of the bonds should be.
I understand from my counsel, based on other securitizations that have issuance advice letters, there's an informal process before the actual live pricing where everyone would go around the room and ensure the designated representative, the underwriters, and the company all agree on the next step. So that, I think that should solve that issue.
Okay. Now, what if you go around the room and everybody doesn't agree?
Then that's, I mean, that's something that would need to be addressed at that time.
And how would you address it?
I think it depends on the issue. Obviously, if the designated representative has concerns, we can discuss with them. But ultimately, the decision on the issuance is Liberty.
Well, ultimately, it's the commission that can approve or reject the issuance advice letter, right?
That's correct, but that would be, as you mentioned, catastrophic there.
So you're not agreeing right now that some other method of dispute resolution, short of outright rejection of that issuance advice letter, would be a better alternative?
That's not something I can commit to here.
Okay. No further cross.
All right, for public counsel,
No questions, thank you. Nathan Williams.
we'll come up for questions from the bench then. Any questions from the commissioners who are on the line?
Judge, this is Commissioner Sylvia. I have no questions. Thank you.
Thank you.
Judge, this is Commissioner Holzman. I also have no questions.
Thank you, sir. I do have some questions. First of all, what is your personal experience with securitization bonds?
Liberty has not issued any securitization bonds to date.
And I assume that means that you've not had any experience anywhere else with them?
I have not, but we do have, we are a very seasoned issuer across our company. We've
Issuing other kind of bonds, you mean?
lots of other kind of bonds, debt, equity-linked securities. In the past 2 years alone, I think we've issued over $4 billion in the capital markets
Okay,
across the U.S. and Canada.
thank you. In your Surrey rebuttal testimony at page 2, lines 22 through page 3, line 2, you state there should not be additional protocols or procedures added to the financing order that could lead to delays in completing the transaction, ultimately adding costs that Liberty's customers will have to pay. What protocols or procedures are you referring to there?
I think additional steps of having additional meetings with the designated representative. Anything that would slow down the process could lead to anything that could lead to delays. You're taking market risk, given our environment right now. Interest rates are going up. Additionally, the carrying charges would continue to accumulate, and that would be additionally securitized.
Okay,
and
so
going
you're
to
just
the-
talking about the risk of delays in general with the market conditions? Is that what you're talking about?
That's correct.
Okay. Can you describe for me what Liberty's proposal for the commission staff and their advisors during the structuring, marketing, and pricing phases? What is your proposal?
I think they would be involved in all facets of the process. Any kind of conference calls, meetings they would be invited to. It's another seat at the table to work collaboratively to issue these securitized bonds.
Okay. And I assume they'd be involved during the selection of the underwriters?
That is something that the company would do.
The company would select the underwriters?
Correct.
Okay. Would they be involved in the marketing?
I'd imagine they'd be involved in helping address any concerns around marketing. Usually marketing is done by the CFO or treasurer of the company, but they would definitely be involved in providing feedback for the process.
Okay. Would they be attending rating agency meetings?
I think it's all facets of the process is what we had indicated, and what the statute also indicates.
Okay. Is the selection of the underwriter part of the process to place the bonds to market?
It is, yes.
Okay. But you indicated that the staff would not be involved in the selection of the underwriters. What's the reason for that?
I mean, I think the ultimate decision comes from Liberty, and we can obviously take suggestions from the designated representative and their financial advisor. We do have a very robust process for selecting underwriters at Liberty and Algonquin.
Can you describe that process for me?
Like months in advance of any potential issuance, we're talking with potential banks, understanding the market, understanding their capabilities, their past record of issuances, meeting with them, understanding the timing of it, potential roadblocks to issuing, and then we would, meet with banks and regroup and go through another round and ask additional questions after we've gone through them all. It's quite a process, given that we are issuing under many different markets that we're not always familiar with, that we want to ensure that we have the best underwriter that would lead to the best pricing.
Okay. And that's the process you use now with regular bond issuances?
Correct.
Okay. Now, switching gears a little bit here, should the commission issue a single financing order addressing both Storm Uri and Asbury securitizations, or should they issue two separate financing orders?
I believe we're requesting for a combined financing order.
And what's the advantages and disadvantages of doing that?
There would be savings on some of the upfront costs of setting up the securitization. Additionally, having a bigger pool of funds to securitize could be more liquid. So liquidity in the market for investors, it's important to help drive down pricing. If it's a smaller issuance, they may not be as interested. So it's important that you have a sizable issuance or two blocks of issuance that are sizable.
Okay. Do you have any estimates of the difference in cost between issuing a single order and issuing two orders?
I believe that I don't have the figures in front of me, as I didn't do the calculations myself, so I can't make an estimate here at this time.
Okay.
But I know there is savings, and I believe Katrina, the company which is Katrina Niehaus, could address that in her testimony, as she's more familiar.
Okay, she'll be here tomorrow. Can you explain the difference between Rule 144A Reg A bonds versus bonds registered with the SEC?
Yeah, so 144A is sold to qualified institutional buyers. These are large institutions. They need to have a certain threshold of assets under management, whereas a SEC registered is available to the public. Anyone could buy.
Okay. And I believe Liberty's petition indicates it'll be issuing bonds registered with the SEC. Is that still the case, or has the position changed?
That's correct.
Okay.
Based on advisement from our structuring advisor, that will lead to the lowest pricing.
Are there any conditions under which Liberty would consider issuing the other kind of bonds, the Rule 144A bonds?
I think we would definitely take advisement from our underwriters who are most familiar with the markets, and if they felt it would lead to better pricing, some better savings for the customers, then obviously we wouldn't be opposed to switching to that type of issuance.
And staff's representative would be involved in that decision
Yeah, I think
consulted
staff's
about it anyway.
correct. It's a full process there that the staff's designate a representative be involved.
What's the minimum dollar value of a securitized property at which a reasonable underwriter would expect sufficient investor interest, liquidity, and bond ratings such that the bonds are issued at the lowest available cost for Liberty's customers? So what's the smallest amount of securitization that would be appropriate?
I think that question would be best answered by Katrina Niehaus.
Should the, switching gears again about the post-financing order process, should the commission require that a bond advisory body be established of Liberty, the commission, public counsel, or PSC staff, and then any designated staff or consultants? Should we have a bond advisory team?
I think the statute is clear that the designated representative would be involved in the process, but Liberty would be the ultimate decision maker.
Okay, I believe that's all the questions I have then.
Thank you, Your Honor.
Any questions in response to the, any recross based on questions from the bench? Beginning with staff.
Yes, Your Honor. I wanted to clarify earlier, you had mentioned the selection of the underwriter, that is a facet of issuing the bonds, and that staff would have collaboration in all facets of that.
That's something I will need to discuss with the team. That's not something I can commit to here.
But if the commission ordered Liberty to allow any staff representative and financial advisor to have input and collaboration in all facets of the selection of the underwriter, Liberty would comply with that order, right?
If that's what was ordered, but obviously that's something I'll need to take back with my team. I can't commit to that here on the stand.
And you had said on the stand earlier, though, that the statute applies to all facets of the bond issuance process,
That's my understanding.
and the selection of the underwriter is one of those facets.
I suppose so.
So Liberty's proposing something less than all facets.
I think ultimately, I mean, I've mentioned that the underwriter, the designator.
Yes or no? Is Liberty suggesting that staff's representative and financial advisor be something involved in collaboration in something less than all facets?
No, we're not.
But the underwriter is one of those facets.
But the ultimate decision maker is Liberty, based on the statute.
But you can't commit that the staff representative and underwriter would have input and collaboration with the selection of the underwriter?
I can take that back to the team, but I agree, collaboration from all facets is what is written into the statute.
And the selection of the underwriter is one of those facets, yes or no?
Correct.
So if Liberty wants to follow the statute, the staff representative and financial advisor would have to have input and collaboration with the selection of the underwriter, yes or no?
Yes.
Thank you.
All right, for public counsel.
Hang on,
Oh, I'm sorry.
I might have a couple more clarifications.
I misinterpreted your thank you.
Does Liberty owe fiduciary duty to its ratepayers?
Yes, they do.
Would the underwriter owe a fiduciary duty to its ratepayers?
No, they don't.
Would Liberty be obligated to repay these bonds in any way once issued?
No.
The ratepayers would.
Correct.
Does the rating agency have a fiduciary duty to the ratepayers?
I don't believe so.
I believe somewhere in your testimony you had mentioned that information provided by Liberty to the rating agencies is usually posted on a website,
Correct.
and that's a secure website,
That's correct.
and that password would be limited to only 1 or 2 members of Liberty's team.
That's my understanding
And
based on.
for clarification, under your proposal, would staff's representative and financial advisor have access to that secure website?
I believe so, yes.
Okay, I just wanted to clarify that. No further questions.
All right, public counsel.
Nathan Williams, thank you, no.
All right. And any redirect?
Yes, thank you, Judge. Diana Carter for Liberty. Mr. Mozandy, you were asked if Liberty would comply with a commission order. Do you recall that?
I do.
Is it Liberty's intent to comply with any order of the commission?
Yes.
Is it Liberty's intent to get the best deal on the bonds?
Yes, with any deal that we issue, it's our intent that we'll get the best deal possible.
You were asked about the commission designated representative being included in in-person meetings, and that was not specifically mentioned in your testimony. Do you recall that question?
I do.
Is it typical to have in-person meetings in your world right now?
No, it's not. No.
If there were to be an in-person meeting associated with this securitization, would the designated representative be invited?
Of course.
And if there are questions from the designated representative, will the company try to answer those questions?
Yes, of course.
What is your concern about the designated representative ultimately having a veto power or decision-making authority, being the one to finally make a decision?
That ultimately the process needs to be very nimble and quick, given that market volatility can change very quickly. So anything that leads to a delay in the process, we're taking a risk, which is ultimately being bared by the ratepayers.
And you were asked about your testimony not spelling out a particular dispute resolution process for during the pricing stage. Do you recall that?
I do.
I believe you fully answered already in response to Judge Woodruff's question, but wanted to give you the opportunity if there was anything else you wanted to explain regarding your concern, the company's concern, on having a formal dispute resolution process set up during the post-financing order process.
Yeah, I think that could also lead to delays in the whole process and ultimately risk of increasing the price of the bonds being issued.
When you speak in terms of timing, how fast is this? Is it a month-long process? Is it multiple months? What are we talking about?
I think it all depends on market volatility, but in past experience, we're prepared and ready to go well in advance of starting the process. So like a month in advance with dates in mind that we would need to go at any time, given the market volatility.
Might decisions be needed? Let me rephrase that. Do you always have a significant amount of time before a decision is needed?
No, we don't. Sometimes we need to be quick on decisions, and taking that advice from our lead underwriters is very important, given that they are the experts in the field.
And when you say quick, what do you mean by that?
I would say not waiting a day or two, going back and forth. It is making a decision that day when they do give the advice.
Thank you. That's all the questions I have.
All right. Thank you, Mr. Masindi, and you can step down.
Thank you, Your Honor.
Thank you. Get some sleep. You're free to go.
Okay, at this point, I believe we'll move over to some public counsel witnesses. Mr. Robinette.
I am so sorry, Judge. I did not hear that.
Okay, we're moving on to Mr. Robinette.
Thank you.
Good morning.
Good morning.
If you'd please raise your right hand. You solemnly swear or affirm testimony about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
This is Nathan Williams, attorney representing the Office of the Public Counsel. Mr. Robinette, would you please state and spell your name?
John Robinette, and Robinette is spelled Robinett.
Mr. Robinette, did you prepare, rebuttal testimony in case number EO-2022-0193, which involves Asbury, and surrebuttal testimony in case number EO-2022-0040, which involves Storm Uri?
Yes.
And that was pre-filed in this case?
Yes.
And did you also prepare, or as part of that testimony, did you also include schedules?
Yes.
And was one of the schedules later filed and at the time the question and answer form of the testimony was filed?
Could you repeat that question?
Was there one schedule that was filed later than the others?
Yes, per the commission's request.
And your testimony that's, your rebuttal testimony from case number EO-2022-0193 has been marked for identification as exhibit number 210. Would you have any changes to that testimony for it to be your testimony here today?
I do not.
And for your surrebuttal testimony from case number EO-2022-0040, it's been marked as exhibit 211. Would you have any changes to it for it to be your testimony here today?
I do not.
Are exhibits 210, 211, oh, and the late filed exhibit has been marked as exhibit number, schedule, I'm sorry, has been marked as exhibit 212. That would be schedule JAR-S-4C.
Yes.
Are exhibits 210, 211, and 212 your testimony here today?
They are.
With that, I'll offer exhibits 210, 211, and 212.
All right, 210, 211, and 212 have been offered. Are there any objections to their receipt? Hearing none, they will be received.
And Judge, I'll just note that they do contain confidential and some of them highly confidential information.
Yes.
With that, I'll tender the witness.
Okay. And for cross-examination, we begin with staff.
Thank you, Your Honor. Kurt Stokes for staff. Good morning, Mr. Robinette. Your schedule JAR-R-4 from case ER-2016-0023, you referred to that in your rebuttal testimony at page 5.
Yes.
Okay, and those are staff's accounting schedules from that 2016 rate case, correct?
They are.
And that was from staff's filed position, so it doesn't necessarily establish an agreed-upon rate base for Asbury, correct?
That is true.
And it doesn't necessarily establish an ordered rate base for Asbury.
That is also true. Those were just my best estimate to arrive at the depreciation expense and how to calculate it.
No further cross, Your Honor.
For Liberty?
Yes, thank you, Judge. Mr. Robinette, do you have your testimony with you?
I do.
Referencing your SIR rebuttal, page 1, lines 13 to 17, you agree with staff's recommended disallowance on the Winter Storm Uri costs due to what you call a lack of availability of Riverton Unit 11. Is that correct?
That's what it says there. My recommendation is actually higher than staff's.
And I was going, was trying to not have a compound question for you, and you got me there. And then you also recommend an additional disallowance on the storm costs for what you say not being prepared with full capacity of fuel oil as a backup for Riverton 11, correct?
Yes.
The Riverton units are located in Kansas, is that right?
Yes.
And the electricity generated from Riverton is used by Liberty for service to customers in Missouri, Arkansas, Kansas, and Oklahoma, correct?
Yes, those are Liberty's service jurisdictions.
And the Riverton units are used traditionally in terms of cost allocation among the 4 states?
I would assume so. I mean, Missouri covers the vast majority of that share, but yes, I would assume they are.
And on page 5 of your rebuttal testimony, you explain your calculations, and you specifically state that for your recommended disallowance, you applied the Missouri Retail Energy Jurisdictional Factor, correct?
Do you mean SIR rebuttal? I'm sorry, I went back to rebuttal.
I believe it was actually on page 5 of your rebuttal where you originally explained that. It is a rebuttal? I apologize.
Well, I mean, there is on rebuttal as well. That's the Missouri jurisdictional for plant balances.
Okay, there we go. And so you did make that jurisdictional allocation.
I did.
Did you also take into consideration the agreement Liberty has in place regarding revenues from Riverton 11 with Mudgemuck?
I did not.
Would your recommended disallowance amount change if Liberty were not receiving 100% of the revenues from Riverton 11 at the time of Winter Storm Uri?
Could you repeat that for me?
Yes, would your recommended amount of the disallowance for Riverton 11 be reduced if Liberty were not entitled to receive 100% of the revenues from Riverton 11?
I don't know, only because it didn't generate, so there would have not have been revenues received for that unit.
But your recommended disallowance amount is calculated based on hypothetical revenues, correct?
Correct.
And so if those revenues would not have been Liberty's, how would there still be a disallowance based on those hypothetical revenues?
So that money still would have come to Liberty, is my understanding, as they are the operators of the system and the unit. They may have had to push a payment to Mudgemuck under that scenario.
Your disallowance, your recommended disallowance, builds upon staff's disallowance, correct? That Liberty did not tune Riverton 11 for winter temperatures?
I would say mine goes further than that. And so I assumed longer hours of operations than what staff had done. I start at a different time of day for the disallowance. And I also add in the fact that, and I'm not sure if it's highly confidential or not, about the capacity and the amount of fuel that was on site.
Thank you. Would you agree being eligible for a Black Start designation is not the same as actually being listed as the Black Start resource in Liberty's system restoration plan?
I don't know that I've reviewed that plan, but I am aware that it's public knowledge that those two units have the capability of being Black Start based on the 2010 IRP.
And would you agree that being capable of being a Black Start unit is not the same as being a Black Start unit?
I think it could be and could not be. I think it's the square and rectangle scenario, where a rectangle may not be a square, but a square is a rectangle.
Are you aware of the Southwest Power Pool protocols that to be a Black Start resource, it needs to be listed in the approved system restoration plan?
I'm not aware of that.
Judge, may I approach?
You may.
Thank you.
Mr. Robinette, I will represent to you that this is Liberty's restoration plan that has been approved by SPP. Are you familiar with that document?
I'm not.
You did not review that document before making the recommended disallowance?
I did not.
Mr. Robinette, are you familiar with Brian Mashimba's rebuttal testimony?
I am not.
You did not review Dr. Mashimba's testimony in this case?
I have not. We have a lot of cases going on, and we had other deadlines in between when I filed rebuttal and the hearing today, so I have not had the chance to review it.
I'm going to ask you some questions and ask if you agree or disagree with the statements. I understand that you may not be able then to give me an answer on the stand right now since you hadn't reviewed Dr. Mashimba's testimony. So feel free to just say to me that you don't have an opinion on that. But I'm going to read some more technical statements, and I'd like to know if you agree or disagree. Do you agree with Dr. Mashimba that Black Start testing is not synonymous with tuning the unit?
I don't know that.
Do you agree with Dr. Mashimba that tuning the unit on natural gas does not improve the performance of the unit when attempting to fire on emergency fuel oil?
I don't know that.
Do you agree with Dr. Mashimba that the natural gas and emergency fuel oil delivery systems are completely separate systems on Riverton Unit 11?
I don't know that, but I would assume that the fuel oil could be trucked in where natural gas more than likely is a pipeline.
Would you agree with Dr. Mashimba that the control valve for natural gas delivery is in fact completely separate from the control valve for emergency fuel oil delivery?
I don't know that. It's been many years since I've been to Riverton, and 10 and 11 weren't really the subject at the time of my visit.
Thank you, Mr. Robinette. And would you agree that each of the control valves have unique flow characteristics that would need to be taken into account during the tuning process for the specific fuel type?
I don't know that for certain, but they certainly would have different types of flow for the different types of material.
And I would like to clear something up that may be a confusion in lots of folks' minds. Winter Storm Uri was not a black start situation or event, correct?
My understanding is that that Empire had not lost all power, correct?
Liberty was not called upon to use its designated black start unit for that purpose, correct? There just wasn't a black start event here.
I don't know what they were called on, but I know that there was power at that site.
In this case, we're only talking about black start because black start units have separate testing requirements, correct?
I honestly don't know if they do or don't have different testing.
What is your understanding then of why we're talking about black start requirements or black start units in this case?
I believe we're talking about these units as resources that Empire had available under an emergency scenario based on the KDHE requirements that they sought a waiver for that did not operate when called on.
And public counsel's and staff's contention is that Liberty was imprudent in that regard because the Riverton 11 unit hadn't been tested within the last 3 years, correct?
I won't speak for staff. I mean, I also have the additional that I don't believe there was the level of fuel that was seen at other facilities.
The Kansas air permit for the Riverton units provides that Liberty may use fuel oil in certain situations for meeting black start testing requirements by any federal or state regulatory agency, correct?
I think there's other requirements, but I believe that is one of them.
And the source of that testing requirement that is the basis for staff and OPC's proposed disallowances here is a NERC requirement, a North American Electric Reliability Corporation requirement regarding testing. Is that correct?
That I don't know.
About the testing to be done every 3 years?
I'm not aware of that requirement. I relied heavily on staff's recommendation and then went looking at other things that were possibly wrong with the situation.
So if staff's recommended disallowance relied on that requirement, then that flows into your recommended disallowance, correct?
It is part of it. It's not all of it, but yes.
And you're not in any way familiar with that NERC requirement only applying to black start resources?
I am not.
And you're not aware of that NERC requirement then only applying to the actual designated black start resource?
I am
In
not.
the restoration plan?
I'm not, sorry.
And again, you didn't review Empire's restoration plan?
I did not.
If you could look for me at your SIR rebuttal, page 4, lines 9 to 14. And this is what you were just mentioning about the fuel oil tanks.
Yes.
And you say these responses show that Liberty took measures to make sure fuel oil tanks were full at all of its combustion turbine units prior to Winter Storm Uri, except for Riverton units 10 and 11.
Yes.
And then you go on to say, taking this into account, this is why you recommend a much larger disallowance for Riverton Unit 11, correct?
Right, because if there was more fuel, it would have been able to run longer.
Since filing your SIR rebuttal testimony, have you learned why Riverton 10 and Riverton 11 fuel oil tanks were not filled up to capacity?
I don't believe I have.
Are you aware of how often fuel oil is used at Riverton compared to other plants?
I know that Riverton 10 and 11 are used very infrequently to begin with compared to the other CTs and combined cycle units.
And are you aware that there are also differences in the plant characteristics between Riverton and the other units in terms of why there'd be fuel oil at the other, more fuel oil at the other units?
Not specifically. I don't know the sizes of the storage at those other facilities. That would be one reason there could be more. And there are more units at Energy Center for certain, but part of those, I believe, are run on a different type of fuel source as well.
Exactly. Other plants use fuel oil more than the Riverton units, correct?
I think it depends on the type of fuel oil, but I know there are jet engines at Energy Center that would be certainly a different type of fuel.
The Riverton units are only able to use fuel oil in a Storm Uri level situation or worse, correct? Because of the air permits?
I believe it's only under emergency scenarios, and Liberty, in fact, had to seek out a waiver to operate it or attempt to operate.
And you did issue a data request to Liberty on that issue, and you received a response from Liberty, I believe it's DR 8500, explaining why there was not more fuel oil at the Riverton units?
The answer is I more than likely asked yes.
Judge, if I could approach to see if this refreshes his recollection?
You may.
And Mr. Robinette, what I'm going to ask you is if this refreshes your recollection on what you might have learned since you filed your sur rebuttal testimony, and then if that changes your recommendation in any way.
Thank you.
And it is just that first page, I believe, Mr. Robinette.
Okay. Could you repeat the question for me, if there was one?
Yes, I was going to ask you if that refreshes your recollection. Does that refresh your recollection about finding out information from the company after you filed your testimony in this case about why there was not additional fuel oil at the Riverton units?
I can't honestly tell you if I've looked at this or not since then with the other deadlines that we've had in place for other cases.
And I certainly understand that. Would you mind taking a look at it now and reviewing it? That was your data request to the company, correct?
Yes.
And after you've had an opportunity to review that, if you could let me know if that changes your recommended disallowance.
Judge, I'm objecting to that. He's already said he doesn't recall. I'm not sure what she's trying to do with this other than get it in as evidence.
I understand your concern, and we'll deal with that when it's offered, or if it is going to be offered. I think the question at this point is still proper.
The response here basically says that the air permits are strict, and Liberty says that it does not require the same amount of fuel oil for Riverton 10 and 11 as it does the other CTs in the fleet.
Does that change your recommended disallowance regarding Liberty having a different amount of fuel oil at the Riverton units as compared to the other generation units?
I don't know that it does. I mean, I was looking at it as what the company did in respect to all the others, and that unit is an outlier of how it operated.
So for your assessment, it doesn't matter if there's a reason it's being treated differently?
No, I don't think that's what I'm saying. We actually hit that emergency scenario. I mean, you see the company filling up everywhere else, and it's my mindset that why wouldn't you fill up there?
And this gives you the answer of why you wouldn't, correct? Because we didn't know Storm Uri was going to happen in advance.
I think there was some predictions that a storm was coming that they were prepared for. I don't know that the extent of the storm was anticipated.
We hadn't hit that target yet to trigger the, what's been called a waiver. I'm not sure that's accurate, but what we've been calling the waiver in the air permit, that hadn't been triggered yet, correct?
You're saying at the time of the filling?
Yes. At the time when fuel oil was procured for the other units,
I don't believe you would have hit the emergency scenario for Riverton 10 and 11 operating on fuel oil at the time of fuel purchase, correct?
and Judge, I'd like to ask just one question in camera, if I could.
Okay, we'll go in camera.
Thank you. Mr. Robinette, in your rebuttal testimony, you described three major investments in Asbury after 2000, the year 2000. If you could look at page 2 of your rebuttal, lines 6 through 9. Give you a second to get there. It states that you believe it is important for the commission to understand Liberty's capital spend at Asbury over its lifetime. Is that correct?
Yes.
All capital spending at Asbury was previously found to be prudent by the commission, correct? Based on what was known at the time the costs were incurred?
I don't know that for certain. I don't know if there have been disallowances over the entire history.
But if the costs came in and were in rates, that means the commission made a prudence determination. Correct?
I don't know that for certain. I know that they would have been ordered based on just and reasonable rates. I don't know if prudence reviews were part of all of that.
Looking at that same section of your rebuttal testimony, you say that ratepayers did not receive the full value of the assets that were promised and expected. Do you see that statement in your testimony?
I do.
And is that based on Asbury being retired early before the end of its expected life?
Right. So when the air quality control system was put on, the life of Asbury was extended, and at the time I was with commission staff, and the life was extended and depreciation rates would have changed to reflect that, and the unit did not make it to that date, correct? And so ratepayers haven't paid in full for that, and I don't know that they would have received the full value as it was built into rates. They did during the time it was operating, but it didn't meet what the last depreciation study had said it was expected to.
It was retired early. Is that our easy way of saying that?
I think so, yes.
You're familiar, I'm sure, with the securitization statute?
I have looked at it once or twice at least, yes.
It's not small, I'll give you that. The securitization statute provides that an electric utility like Liberty may petition for a financing order to finance energy transition costs. Are you familiar with that? That's why we're here on Asbury.
Yes, I believe it states that energy transition costs, yes.
And energy transition costs include, in the definition, the undepreciated investment in the retired electric generating facility, correct?
I don't have it in front of me, but I will take your word that I would assume that is likely one of the many options for an energy transition cost.
And that when we file a petition, like Liberty did here, they were required to include in that petition a description of the electric generating facility that was retired prior to the date that all undepreciated investment had been recovered through rates, correct?
I don't know that for certain, but it wouldn't surprise me that you had to describe everything that you were seeking.
So essentially,
Judge, I'm going to object to her just reading the statute and then saying, does the statute say what the statute says of this witness? I'm not sure where she's going with this.
my very next question. Thank you, Nathan.
I'll overrule the objection. You can ask your question.
So the securitization legislation, that statute is specifically about early retirements.
you're asking specifically only about the energy transition? Because there's also the
Yes.
securitization for like major storm.
Yes, on Asbury, it's only pertaining to the undepreciated amount, the securitization statute.
No, I don't think it is, because it also includes like an allowance for dismantlement, so.
It only applies if the facility were retired early, correct? It wouldn't come into play if you waited until all of the amount had been collected through rates?
Judge, I'm going to object to the question as vague. I'm assuming we're to the second question because I heard two, but I don't know what amounts being collected in rates that she's referring to.
Can you clarify your question?
I can, and maybe it helps if I back up. Mr. Robinette, the testimony that we just discussed, your rebuttal testimony on page 2, lines 6 through 9, you agreed that your concern, public counsel concern, is that Asbury was retired before the end of its expected life.
Yes,
It was retired early.
yes.
Thank you. That's all the questions I have.
Okay. And then we'll come up for questions from the bench. Do we have any questions from the commissioners online?
No questions, Judge.
Thank you. That was Commissioner Holtzman, I believe. I do have some questions.
That's correct.
Sorry. I do have some questions, and first of all, are you aware of how and where fuel oil is stored at Riverton?
I believe they have a tank with a certain level of capacity on site, and my best recollection is that it is outside and not inside of a facility.
Okay, do you know if it's individual tanks for Riverton 10 and 11, or is it a combined tank?
I'm not entirely certain, but it would not surprise me if it was a combined tank based on their locale at the facility.
Okay. Let me just ask a general question about the Riverton units. I believe their testimony yesterday, there were 3 units there, 10, 11, and 12. Do you know what happened to units 1 through 9?
I know 7, 8, and 9 were all retired at the same time,
Okay.
and that was prior to the 2016 case, and I believe that case actually involved dismantlement costs for them.
Okay, so is this an old facility that only a few of the units are left in?
Yeah, so if I recall correctly, this facility at one time held the generator that was part of the 1903 World's Fair named Old Kate.
Okay. So it's a little old, or parts of it were.
Yes.
Okay. Now, in your survey rebuttal testimony at page 2, you stated you had discovery for some parameters that might affect the time period of hypothetical operation. Did you receive that you were still looking for some discovery on those? Did you ever get that discovery, and did you make any changes? Does that impact your disallowance calculation?
So it's the best I have. I tried to reach out to the Kansas Department of Health and Environment to figure out the exact timing of when the waiver was granted. I still haven't heard back from them, so I estimated a certain time of day based on statements that were in a report attached to Mr. Olson's testimony that said they got a waiver in the afternoon. So I made a recommendation to start at a certain time in the afternoon,
Okay.
and then ran the unit until the market prices were below what I had calculated for the hourly fuel cost for that unit.
Okay. That's all the questions I have. Is there any recross based on the questions from the bench? All right.
Yes, Your Honor. This is Kurt Stokes on behalf of staff. Mr. Robinette, do you remember when you were asked on cross by Liberty's counsel that Uri was not a Black Start event?
Yes.
Did Liberty know that going into Uri?
I don't think they would have known that, no.
They didn't know whether Uri would be serious enough to be Black Start or not.
I don't think they would have. I don't think they would have, no.
Was your rebuttal testimony criticized for using a, quote, how it turns out standard for prudence?
I would object, Your Honor, that that redirect question goes beyond the scope of any questions put to Mr. Robinette so far.
It goes directly to the question that Uri was not a Black Start event.
I didn't ask any questions about whether Uri was a Black Start event. That came from council, and this is recross based on questions
Based on
from the
bench,
bench.
okay.
So I'll sustain the objection.
Okay. I think, there we go. Oh, yeah. Dual fuel capability of Riverton. Have ratepayers paid extra for Riverton based on its dual fuel capability?
I would say they've paid for the availability of both and for both to have access to both.
Okay. No further questions.
All right. Any recross from Liberty?
No, Judge, and I apologize. I was confused there on what stage we were in.
Okay, any redirect?
Just a few questions, I believe. Nathan Williams. Mr. Robinette, do you recall there was a lot of questioning during cross-examination and commissioner questioning about a Black Start capability and Black Start testing? You recall that?
Yes.
What is the relevance to Black Start with regard to your recommendation for a disallowance based on Riverton 11 being capable of being run during Storm Uri, if potentially?
Answers I don't really know. It was more based on that unit is there, and I think with the company's actions to get the waiver and it not being able to fire it was more based on the availability of fuel and using springboarding off of staff to come to an adjustment.
Well, what does Black Start capable mean?
My understanding is that Black Start capable would mean that that unit is essentially able to fire without the grid. It's the first unit to come up, and it would then be used to provide power to the rest of the units to bring those up, because certain ones of those need, every station usually has some sort of energy usage in order to bring it up and keep it running. So it would provide power to the other facilities in order for them to start.
So it impacts reliability in terms of being dispatchable.
In a blackout, it would be the first unit able to come on to repower the grid.
No further questions.
Okay. Then, Mr. Robinette, you can step down. We're due for a break. Let's come back at 10 minutes after 10. second, love to get back on the line here. There we go. You solemnly swear affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
So help me God.
Thank you.
Morning, Mr. Riley.
Morning, sir.
Would you please state and spell your name?
My name is John S. Riley, R-I-L-E-Y.
Mr. Riley, did you prepare and have pre-filed rebuttal and surrebuttal testimony for these cases before the commission here today?
Yes, I did.
And those have been marked as exhibits 208 and 209. For those to be your exhibits to be your testimony here today, would you have any changes to any of them?
No, sir, I don't believe.
Are they then your testimony here today?
Yes, they are.
I offer exhibits 208 and 209.
208 and 209 have been offered. Any objections to their receipt? Hearing none, they will be received.
I tender the witness for examination by others.
Thank you. Beginning with staff.
Thank you, Your Honor. Kurt Stokes for staff. But Mr. Riley, you stated in your rebuttal testimony at page 22, lines 12 to 13, that bonds aren't taxable, or, bond proceeds aren't taxable.
Yes,
Is
sir.
that correct? Have you been able to review Revenue Procedure 2005-62, which was mentioned in the direct testimony of Ms. Niehaus, and I think it was also in the surrebuttal testimony of Ms. Bolin?
I think I'm familiar with what you're referring to, yes.
And for clarification, when the bonds are actually sold and issued, that is not taxable, correct?
That is correct.
But as the company collects the securitization charges, that there is an income tax associated with those charges.
I actually have said that in testimony, yes.
Okay, okay, I just wanted to make sure we
Right.
had that clarified. Okay. No further no further cross.
For Liberty,
Yes, Your Honor, Dean Cooper for Liberty. Let's just kind of set some time frames here, Mr. Riley, to start with. Would you agree that the rates from case number ER-2019-0374, what's commonly referred as Empire's 2019 rate case, became effective on or in September of 2020, and those rates were no longer effective at the end of the day on May 31st of 2022?
I could take your word on the start. I know that rates became effective at the end of May.
Or the 1st of June of this year,
June
new
1st.
rates. And what we refer to, I think, in various places as the Asbury AAO started, or was to start, on January 1st of 2020, correct?
Yes.
Now, you describe in your testimony, obviously, a number of issues that you've raised with regard to the company's calculation of energy transition costs that it hopes to securitize. Do you have your surrebuttal schedule JSR-S-01 before you?
Yes, sir.
And on page 1 of that document, among other things, I suppose, it purports to summarize the differences between your calculations as of surrebuttal and the company's calculations, correct?
Yes.
And if we look at, and to that end, there's a column for company and a column labeled OPC, correct?
That's correct.
Now, would you agree that the number you have used for the company's position for Asbury ADIT does not accurately represent the company's position on that issue?
Yes, you're right. It is not the net present value that company has calculated.
And so to truly get back to the company's position, you'd have to use a different number than what you've reflected on that exhibit, correct, or on that schedule?
That would be correct.
Now, in your rebuttal testimony, I think you indicate that there should be no net present value applied to the aided amount, correct?
I believe my position is that it should run through the AAO first. So if it goes through the AAO, you wouldn't have a net present value. Right.
So, and I think that in your testimony, you first kind of wondered why the company applied the NPV calculation, and then kind of surmised that perhaps it was section 393, 1700.2, sub 3, sub C, sub M, correct?
I'm glad you said that.
Yeah, I think you actually make that citation in your testimony, correct?
With some help, yes.
Yeah. And if we look at that portion of the securitization statute, as to aid it, it indicates, doesn't it, that the customer credit shall include the net present value of the tax benefits calculated using a discount rate equal to the expected interest rate of the secured utility tariff bonds for the estimated accumulated and excess deferred income taxes at the time of securitization, including timing differences created by the issuance of securitized utility tariff bonds amortized over the period of the bonds multiplied by the expected interest rate on such securitized utility tariff bonds. A lot of words there, but certainly you would agree, wouldn't you, that there is a contemplation that there's going to be a net present value of the tax benefits, correct?
Within the securitization statutes, yes. They have spelled out what you just said as a net present value of the accumulated deferred income tax.
Well, and even in that context, I think if I look at your rebuttal testimony, you surmise, or you sort of indicate an opinion that the use of the MPV as designated by the statute would be a confiscatory act. Is that accurate?
It's probably accurate. I myself think so.
Yeah, and you say probably, but what I'm looking at is on line or page 13 of your rebuttal, and lines 6 and 7.
I see this recalculation as a confiscatory act. That is my uninformed opinion, as I have not sought the advice of counsel regarding.
Yeah, that's where I was going next.
Okay.
Was that to the extent that's your opinion, it's an admitted uninformed opinion, correct?
Well, sure.
Yeah. Looking back at that first page of JSR-S-01, and I'm going to kind of go down the list of the items at the top of the list there. And would you agree with me that the number you reflect for net retired Asbury plant for the company is essentially a number that the company and the staff have agreed on?
I think that's probably accurate, yes.
And the same question as to Asbury environmental regulatory assets?
According to the most recent reconciliation that was sent out yesterday, that would be accurate.
And then same question as to the Asbury fuel inventories, staff and company are on the same, at the same place on those?
You're both wrong, yes.
And as to Asbury excess aided, I don't know that they're dollar for dollar the same, but they're in pretty close proximity, staff and company, correct? They're both at 12 million and a little bit more.
That's a safe assumption, yes.
Okay. Asbury, additional Asbury decommissioning costs, phase 2, that's the same between staff and company, isn't it?
Phase 2, yes.
Okay.
All three of us are in the same.
Now, let's go back to excess aided for a minute. and we pointed out the difference. Staff and company are a little over 12 million, and if we look at your schedule, you're just shy of 17 million, correct?
That's correct.
And if I understand your testimony correctly, the difference is because you don't recognize any excess aided having been returned to customers through rates after Asbury was retired, correct?
That's my position, that it's stopped, the clock stopped when they retired it.
Now, having said that, the return of excess aided was built into Liberty's rates up through the end of May of this year, correct?
It's my understanding from staff, yes.
Now, near the bottom of your schedule, same on page 1, you have a cash working capital amount of $15,205,731, correct?
Yes, sir.
And before we go on, would you agree with me that staff and the company have a cash working capital amount in each of their AAO liability calculations?
I'm not sure about staff. I know that company had originally, when they filed, had an amount built in for cash working capital, but to be honest, I can't put my finger on staff's.
And you just don't know as to staff?
I don't know.
Could be that they do have a cash working capital number, correct?
Yes, sir.
Now, your cash working capital calculation, I believe, is found on page 5 of this schedule. Is that right?
Yes, sir.
Now, they're not identified, but I assume some of these columns represent your lead lag days.
Yeah. Yes, sir.
Which ones?
You would have your lead lag column. Well, the expense lag is almost in the middle of the page. That would be, if you're looking, 45.04, 45.04, going on down. I pretty much took that from what staff did on their lead lag in the last case, I think.
The 4504 was from what staff did.
Yes, it was, I didn't reinvent the wheel there. I took what they had.
How about the next column?
The 365s were all representative of collections that did not get paid out. The 181.24 for the property taxes would have been a staff calculation, as well as the 12 for payroll and the 91.11 for the interest. Those would have been staff calculations. The 365 would have been mine.
Those were your calculations, and those would not have been numbers that were utilized in the setting of rates in the 2019 rate case, correct?
No, they would not have been.
So would you agree with me that what you did was not an attempt to approximate what part of the cash working capital in the 2019 Empire rate case was represented by Asbury, but you essentially performed a new calculation with your new inputs?
I performed similar calculations using what I know and what my inputs were to the cash working capital calculations.
And at least as to those three that we identified, new values that were not a part of the 2019 Empire rate case, correct?
That would be correct.
Now, if we turn over to the next page, page 2 of this schedule, is this essentially your version of the AAO liability?
Yes, it's an accurate statement.
And one of the items on there is property taxes, correct?
Yeah, line 24.
And when I look at that, I guess I'm curious, because as I look at line 24, I see that through June of 2021, you've got an amount of $2,860 and, or $860,000 and $4. Hopefully, I didn't say that correctly, but let's see if we're on the same sheet of music. A little over 2.8 million, correct?
Correct.
And that represents from the start of the AAO through June 21st, which would be about 18 months, correct?
That's what I've been told.
And so then in the next column, you represent that you're extending that through May 2022, which essentially would be 12 months. And yet you reflect a number that's twice that 2.8 million in the first column, correct?
That's correct.
And ultimately coming with a property tax of 8.5 million and some change that you represent is a 3-year number, correct?
That's correct.
Now, going back to kind of where we started, the rates from the 2019 Empire rate case ended essentially as of June 1st of this year, correct?
Yes.
And so would you agree that from January 1st, 2020 through the end of those rates was a period of 29 months?
Yes.
Now, I guess here's the why question. Why is your 1-year calculation from June of 2021 through the end of May 2022 twice as much as what was utilized for the first 18 months?
Property taxes are calculated on January 1 of every year. They have to be paid. They're not due. They have to be paid without penalty by December 31 of the same year. So when calculating what your expense would be for property taxes, you have to look at each January 1st, not how many months, but by how many January 1st, because all property taxes are due, are calculated and are expected to be paid by the owner that owns it on January 1. So taking the 2.8 million as of January 1, 2020 would have been due the end of that year. Going to January 1 of 2021, you would have another bill for 2.8 million, and going to January of 2022, you would have a third bill for 2.8 million. So if you've ever bought a car on any day of the year other than January 1, you don't owe any property taxes for that year. Your clock, as far as that goes, would be the following January 1 is when the assessor would bill you for property taxes. So we have 3 Januaries.
Okay, so I think we're going 2 different directions here. Because would you agree with me that what we are trying to capture in the AAO liability is the amount of property tax included in Empire's rates that are associated with Asbury?
There'd be 3 years' worth of rates associated with Asbury.
But would there not be 29 months, as we discussed before, of a period that covers the time that AAO was in effect and there was still an Asbury property tax amount built into rates, correct?
It doesn't, with property taxes, it doesn't matter if it's 29 months or 22 months or actually 29 months or 26 months. It matters if you own the property on January 1 of that year. So to say, well, we need to stop property tax on the 29th month, it doesn't work that way because it was due the first of the year.
But you're talking about the company's obligation, correct?
Company's obligation, yes.
And you're not you're not talking at all about what was built into rates and would be assumed to be paid by the ratepayers on a monthly basis.
On a
correct?
monthly basis, that would have fallen under the cash working capital calculations. And yes, you would care if it was 29 months or 24 months.
But again, your assessment is solely on what the company was paying in property taxes and not what was built into rates over that 29-month period, correct?
No. I had calculated cash working capital for property taxes. And that would be on a monthly basis.
But as to your property tax adjustment,
Property tax adjustment it would be a different animal than the CWC calculation.
correct. So here we are. Let's go back. This is one of those items where the staff and the company are pretty close, correct?
I think so, yes.
Just slightly over $4 million each on property taxes.
Right,
And you're at 8.5 million and some change, correct?
correct.
And again, I take it from your discussion that your 8.5 million in property taxes that you use as a liability in your AAO liability does not seek to identify the amount of property taxes that were in Empire's rates associated with Asbury. Is that correct?
No, I think mine are the accurate calculation of the expense.
I didn't ask you whether they were accurate or not. I asked you whether they tried to assess what was in Empire's rates for Asbury property taxes from January 1st, 2020 through the end of May of 2022. Or did they try to calculate something different?
No, as I said, the calculation starts January 1. So if you get to 3 Januaries, you've got 3 years of expenses.
Whether or not those 3 years of expenses have been built into rates, I take it, correct?
They're built into the rates.
Let's talk ADIT for a minute. Now, we always say this, ADIT's about tax timing differences, correct?
Yes,
So money is received for taxes that'll be paid, assumed to be paid in later years, correct?
yes,
Because of the function of primarily accelerated depreciation.
a timing difference, yes.
And in the interim, those amounts paid by customers that exceed the current taxes are used to reduce rate base, correct?
Accumulated deferred income tax is a rate-based reduction, yeah.
Yeah, that's the ADIT. And ultimately, those deferred income taxes, again, are used to reduce the rate base amount that's used to calculate the rate, correct?
That's correct.
And ADIT does not have, within the rate-making context, does not have a dollar-for-dollar impact on annual revenue requirement, correct?
Rate-based rate of return.
If you have, and this is kind of my example, that I used with Ms. Bolin yesterday, I mean, just a real simple example. If we've got $1,000 in rate base, our ADIT is $100, that doesn't mean that the revenue requirement's gonna be $100 less, does it? It mean, I'm sorry.
No, if I understand you correctly, it would be $100 times rate of return and that sort of thing.
That's what would benefit the customer, correct?
Yes.
Okay. Your Honor, may I approach the witness?
You may.
Mr. Riley, what I have handed you is from, I believe, Exhibit 21 in this case. And within that exhibit, it is what has been marked as CTE-13 Asbury. Do you see that?
Yes, sir.
Okay. Now, this is Ms. Emery's calculation of her ADIT number, correct?
I think so.
Now, what I really want to focus on is kind of a continuation of our most recent discussion about the impact of ADIT in rate making. So just to kind of set this up, you can see on the left side that there is an Asbury ADIT amount of $35,665,767, correct?
Yes, sir.
And in that first column, that's taken, it's split over 13 years and essentially amortized over 13 years, correct?
Yes.
And in the next column that says balance ADIT, that reflects the balance after each year of amortization, correct?
Yes.
Now, let's skip over then to the return on rate base number. That 6.77 it's a number that's been used in this case some, correct?
That's correct.
And the far right column then, would you agree, is a yearly calculation of a revenue requirement benefit to customers from the balance of the ADIT at each of those 13 years?
I'm not quite sure I could say that because I'm not really sure what the middle columns are, the 2.47 in this running balance.
Yeah, and we can talk about those, but let's skip those just for a second, okay? And let's see. Do you want to do some calculations? You want me to do some calculations, or do you, or do we want to eyeball what this is?
So are you implying that the running balance in the second column
The balance ADIT column, yes.
times the rate of return of 6.77 provides a reduction in revenue requirement, I guess, for lack of a better term, of the final right side column?
That's correct.
Okay.
Would that be consistent with your understanding?
I think I can follow that, yeah.
Okay. And we probably assume, the way that's done, that there's a rate case every year. Those amounts wouldn't necessarily change on a yearly basis, I suppose, for rate-making purposes. But you generally agree that that process would reflect the customer benefit associated with ADIT within a rate case.
Anytime you're going to try and make these kind of reviews, and you would look at your balance of accumulated deferred income tax times the rate of return, you can calculate the benefit to the ratepayer of that rate base reduction. I mean, I don't necessarily agree with what she's done in her.
With her assumptions, but the process would be consistent,
Yes, the
correct?
process is that way.
Now, let's go back to the middle two columns, and maybe you don't understand what these are necessarily, but let me propose this to you. Does the summary at the bottom look like the company's position on the net present value of the ADIT that's been put forward in Ms. Emery's testimony?
I think it seems to be pretty close, 4.7, yeah.
And the 2.47 would have been the securitization yield that the company used
Yeah.
for its testimony, correct?
Yeah, that's what was the going rate, I believe.
Okay. Now, I'm going to skip subjects here for you for a second. In your surrebuttal, and this is on, I don't know, pages, let me make sure before I give you a page number here, Mr. Riley. Pages 8 through 12 of your surrebuttal, you discuss a tax deduction offset associated with Storm Uri, correct?
Yes.
And that's a big, I would describe it as a big offset. Would you? I think about $64 million.
Yeah, I calculated the original tax amount and then grossed it up.
Now, as a part of that testimony, and I think this is on, starts on page 9, you say that inclusion of this adjustment could be allowed under a couple of sections of the securitization statute, correct?
Yes, sir.
And then the first section that you cite has to do with energy transition costs, correct?
Yes, sir.
And the Storm Uri amounts are not energy transition costs, are they?
Well, I'm not altogether sure. Can you repeat that question?
Yeah, I guess my understanding would be that what we're talking about in regard to Asbury are costs that would be energy transition costs, but that Storm Uri would fit under a different category of qualified extraordinary costs. Is that consistent with your understanding?
So you're saying that Storm Uri would be under a different section of the statute than the energy transition costs?
That's what I think. What do you think?
I didn't split that hair. I more went with the other applicable capital and operating costs, accrued carrying charges, and deferred expenses. So I put them both under the same category.
So if Storm Uri costs would fit under qualified extraordinary costs, then this energy transition cost section you've cited would just be inapplicable to your point, correct?
I'm not sure if Storm Uri would fall under both, or if they're mutually exclusive, or
You just don't know.
no.
Now then after that, you have a definition for financing costs, correct?
It's
Starting on line 25.
right.
And that's the other section that you think may provide some authority for your tax deduction offset here for Storm Uri, correct?
That's correct.
And as I read that, the one provision that you highlight is the E about any state and local taxes, franchise, gross receipts, and other taxes, so on, including commission assessment fees, whether paid, payable, or accrued, correct?
Yes.
Now, would you agree, however, that if you look at the first couple sections of that definition, what's being referred to is costs associated with securitized utility tariff bonds? For example, subsection A, interest and acquisition, defeasance, or redemption premiums payable on securitized utility tariff bonds?
Yes.
And your proposed tax deduction offset doesn't have anything to do with the security bonds, does it?
Well,
It's not a function of the issuance of those bonds, is it?
as you go on down, you run into any taxes and license fees and any other fees imposed on the revenues generated from the collection and securitized utility tariff charge. There aren't any. There's no bonds aren't taxable, but they put in a provision just in case they are. So it kind of falls under the idea that any sort of taxes that may be associated with this event could fall under this provision.
But your deduction really doesn't fall under the issuance of the securitized bonds, does it? It is merely a calculation based upon a federal income tax return that's already been filed, correct?
It's based on composite tax rate times the expected tax loss.
Now, are you aware that ADIT associated with Storm Uri is in rates and benefiting Liberty's customers as of June 1 of 2022?
No, I'm not. I'm not familiar with ADIT being associated with a storm.
How about the fuel and purchase power costs associated with that storm?
That would fall into the $204 million that company claims as their loss.
But in your opinion, none of those dollars would have any impact on the ADIT for the company?
The definition of accumulated deferred income tax, no, there is no accumulated deferred income tax related to the storm. Unless you want to talk about a net operating loss that carries on, you would have some sort of deferral, but
what was your participation in the last Empire rate case?
that'd be the 2021 case?
I'm sorry, the case that just resulted in new rates the 1st of June.
That'd be the 2021 case.
Yes.
I participated in that one, yes.
That's all the questions I have, Your Honor.
Okay. Then we'll come up for questions from the bench. Any questions from the commissioners on the line?
No questions, Judge.
Thank you, Commissioner.
Here either, Judge. Thank you.
Was that Commissioner Kolkmeyer?
Yes, sir.
Okay, thank you. And the earlier was from Commissioner Holtzman, I believe. Just so we have it clear on the record.
Yes, the first one was Commissioner Holzman. The second one was Commissioner Kochmeyer.
Thank you. Okay, I have no questions from the bench either, so no need for recross. Any redirect?
Thank you, Judge. You bear with me for a moment. On your, Nathan Williams, on your schedule JSR-S-1, on your cash working capital calculations, you remember Mr. Cooper asking you questions about that?
Yes, sir.
And there's one column that has the number 4504 in it throughout the column. As I recall, you said you obtained that number from staff. What does it represent?
That is the number of days. It's the expense lag that at times staff had calculated to represent the number of days the expense is out.
And then the next column over to the right, it starts with 365 and has some different numbers through it. What do those numbers represent?
Those numbers represent when the actual expense is paid through the calculation. Like property taxes are paid at the end of the year, so the time lag is quite a bit different. You'll notice it's like 181 days. However, you look at payroll, which is, paid every week or every 2 weeks, and we're just looking at a 12-day turnaround.
You've explained, I think, all of the numbers pretty well, except for, I guess, interest in the 365 days. Would you explain why the numbers are 365?
Well, in the last Spire case, and the case numbers escape me right now, but the commission determined that that recognizing that if you do not pay your income tax total being federal, state, to a taxing authority, yet you collect it from your ratepayers, that they recognize that the time frame of payment would last a lack of a payment would last the entire year. So to recognize that, you would say it was a 365-day lag. So what I did with tax on Asbury profits, because obviously it was never paid out, the fuel inventory, which I contend never existed, but was built into rates, so it was paid for, but there was no payment of the inventory. And then the tax on the fuel profits, there was no payout of that, so those three would show up as a 365-day lag, and using that with the 4504 makes a net lag of almost 320 days.
Do you recall Mr. Cooper asking you about the Storm Uri tax offset?
Yes, sir.
What is your view about why that offset's appropriate, setting aside references to statutes?
Well, they of course have come in for Storm Uri securitization and claimed a certain amount of loss. We're, quoting here, a loss on how much they had to pay for purchase power and fuel and whatnot, and how since it of course did not run from the fuel adjustment clause, they didn't get a compensating return of revenues on that, and they're claiming a loss. So I had sent a data request to them and asked them how much they expected to claim, and don't have that right in front of me, but it was $204 million that they expected to reflect on their income tax return a loss. Now, when you talk about losses and gross receipts and that sort of thing, they all can be commingled together, and the company could be healthy enough that it's not actually going to show a loss. However, as they requested the securitization, they claimed that they had $204 million that they were not compensated for. So on a tax return, you would look at that and say, if you're actually claiming $204 million and not getting any revenue on it, that would be your calculated loss. And if that's the case, then you just take the composite tax rate of 23.84, multiply it by the $204 million, and you come up with your tax savings that you expect to claim on your next tax return.
And does that reflect how that tax benefit would flow in customary rate making?
Well, that's my argument, is it won't show up in customary rate making, is that because of the timing of when this will be their next rate case. I don't believe the commission will be able to go back and go, oh, you had a rate, you got a tax break in 2021, and they're having a rate case in 2023. That's my argument, is you need to address it here now, because they've got a tax benefit that will fall through the cracks, and there won't be any benefit to the ratepayer, but there's certainly going to be a $48 million benefit to the company. Because they're going to claim $204 million, actually quite a bit more than that, but as far as taxes go, $204 million of expenses that don't have corresponding revenue. So they're going to claim, you know, they're going to be $204 million less in taxable revenue than if this could flow through the fuel adjustment clause and go through rates and that sort of thing. So that tax break needs to be addressed now, because I don't think it can go back and get it in the next rate case.
Mr. Riley, there were some references to Liberty's last rate case, what's been referred to as the 2021 case. Recall that?
Yes, sir.
Was Storm Uri an issue in that case?
Yes, it was. I'm not sure the exact sequence of events when securitization statutes were passed, but it was the company's intention to securitize Storm Uri, and they were not going to run the expenses through that rate case.
Well, the commission order in that case did not address Storm Uri in terms of impacts on rates, did it?
I don't think so, no. I can't quote the report and order, or the stipulation, but no, it was not.
No further questions.
All right, then, Mr. Riley, you can step down.
Yes, sir.
And the next witness is Dr. Mark.
Judge, I need to locate Ms. Carter before we move forward, if I
Okay.
could.
Okay.
delay in the hallway. Sorry about that.
Before we swear Dr. Mark, I do want to tell everybody that we'll need to break for agenda at about 11:45 if we haven't finished Dr. Mark at that time. So I may interrupt you in the middle of testimony. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may inquire.
Nathan Williams. Pardon me. Good morning, Dr. Mark.
Good morning.
Would you please state and spell your name for the record?
My name is Jeff Mark. That's Geoff. Last name is Mark, Marke.
Dr. Mark, did you prepare in written form rebuttal testimony that was pre-filed in this case and that is these cases actually and has been marked for identification as exhibit number 204?
Yes.
And did you also prepare in written form rebuttal testimony for case number EO-2022-0193 that pertains to Asbury, which has been marked for identification as exhibit number 205?
Yes. Yes.
For those exhibits to be your testimony here today, would you have any revisions to them?
I do.
And what is your first revision, and which piece of testimony, testimony would it be to?
It's the rebuttal testimony, page 4, line 16. It currently reads as follows. The statute envisions a 1-for-1 replacement, not an 11-for-1 replacement. I would revise that to say the statute envisions a 1-for-1 replacement, not a 6-for-1 replacement. And that's 200, 400, 600, 800, 1 billion, 1.2, so 6 for 1 at the 200 mark. Thank you.
And with that revision, do you have any other changes?
I do not.
With that revision, are exhibits 204 and 205 your testimony here today?
Yes.
I offer exhibits 204 and 205.
All right, 204 and 205 have been offered. Any objections to their receipt? Hearing none, they will be received.
I tender the witness for examination by others.
Thank you. Beginning with staff.
Thank you, Your Honor. Kurt Stokes for staff. In your rebuttal testimony, page 20, lines 4 through 9, you mentioned 3 problems with selling Asbury to a third party.
Yes.
The first problem I see is that Asbury would compete with other Liberty resources, and a second problem is that a wind farm would incur additional interconnection costs. Is that correct?
That's correct.
Is there a third problem? I didn't see a third in there.
There may have been. I can't think of it off the top of my head.
That was just a clarification question.
Right.
The next thing I want to ask is about the 95.5 sharing mechanism.
Okay.
Are you familiar with the FAC case that Liberty filed to remove extraordinary costs related to Winter Storm Uri?
Only vaguely.
Okay. But you are aware that there was some discussion about where to set the level for what qualified as extraordinary and not?
Yes.
Okay. Are you familiar with the AAO that Liberty filed for their Winter Storm Uri costs?
I am.
Did Liberty have a specific request in that case about some assurance of recovery?
That they wanted it.
Yeah.
Yeah.
And they based the request for some assurance under the AAO on the idea that they would otherwise be entitled to recover it under the FAC. Is that right?
That's correct.
And they're taking a different position here, right?
That's my understanding.
That, the FAC doesn't apply.
That's correct.
Okay. Let's say a major storm hits in the future and then there's extraordinary costs. Are you with me so far?
I am.
And let's say that Liberty's been allowed to recover 100% of their extraordinary costs for Winter Storm Uri here. What would the Office of Public Counsel have to do to figure out going forward how do you balance the savings of the securitization less the cost sharing under the FAC? What position does that put you in?
I would defer that question to OPC witness Lena Mantle. It's probably a better one for that.
Okay.
Yeah.
No further questions.
All right, for Liberty.
Yes, thank you, Judge. Dr. Mark, I'm going to first ask you a follow-up to what Mr. Stokes asked you. I believe he asked you if Empire Liberty is now saying the FAC doesn't apply, but previously said it applied. And I believe your answer was yes. Is that correct?
Yes.
But isn't it correct that at no time did Liberty try to seek recovery of the storm costs through the FAC?
I don't know.
You don't recall in that initial FAC filing that Liberty proposed to not have the extraordinary storm costs flow through the FAC?
Again, I'd ask witness Mantle. I was involved in the AAO case. I'm more familiar with that.
So
I know that-
perhaps you don't know if there was a change in position by the company?
If my understanding, again, it's the 95.5. So the position is through the FAC, you have a 95.5 at play. And the position of the company right now is that the 95.5 is not applicable.
Correct, thank you.
Okay.
Referencing page 1 of your rebuttal testimony, starting at line 19 to page 2 of your rebuttal testimony, line 1, you mentioned the remaining balance of the air quality control system, the AQCS. You see that in your testimony?
I do.
And you contend that those costs that have been collected by ratepayers should have instead been borne by shareholders. That is your position?
That's correct.
The costs for the AQCS system were already in rates, as you said. So those costs were previously found by the commission to be reasonable and prudently incurred based on what was known at the time they were incurred, correct?
At what point are you specifying that?
When they first came into rates, that means they had been found to be reasonable and prudent when they were incurred?
So in the initial investment?
Yes.
Yes,
Including the AQCS.
that is correct.
On page 5 of your rebuttal at lines 18 to 21, you mentioned that Liberty chose to build the wind capacity.
I'm sorry, Ms. Carter. Page 5, what?
Yes, page 5 of your rebuttal, lines 18 to 21.
Okay.
You mentioned the wind projects.
I do.
At the time the commission issued its final order in the customer savings plan docket, perhaps I should back up. Are you familiar with the customer savings plan docket?
I am.
At the time the commission's order was issued in that docket, Asbury had not been retired, correct?
That's correct.
And Asbury still had not been retired when the commission issued the CCNs for the wind projects, correct?
That seems reasonable. I'll take your word for it.
Turning ahead to page 19 of your rebuttal testimony, lines 19 to 22. Regarding Asbury, you say that Liberty shut the plant down and could no longer operate it on December 12 of 2019. Is that your testimony?
Yes, it is.
At that point, Asbury was still staffed by Liberty, correct?
That is my understanding.
And
By staffed, I mean at least somebody was present there.
yes, people were at the plant. And Asbury still had all of its permits in place after December 12th, correct?
I don't know.
Are you aware of any of them having expired as of December 12th?
I can't speak to that, I'm sorry.
And you're aware that Liberty provided testimony that after December 12th of 2019, they were still looking for economical coal to burn at Asbury.
I think witness Robinette would have probably been a better one to ask those questions for.
Okay. At that time in 2019, the Southwest Power Pool had a requirement to provide 6 months advance notice of a retirement. Is that correct?
Yes,
And 6 months after Liberty gave that required notice would be March 1, 2020, correct?
could you repeat the first question again?
Yes, that looking back at the relevant time period for Asbury, the Southwest Power Pool requirement was for them to be provided 6 months advance notice before a plant was retired?
Again, I would honestly say that witness Robinette would probably be the better witness to opine on the timeline of events that happened with the SPP and with Asbury shutting down.
But your testimony, you state that Liberty shut the plant down and could no longer operate it
That's
on
right.
December 12th of 2019,
That's correct.
but you're not aware whether or not it could or could not have been retired at that time based on the SPP protocols?
I think the company's putting way too much emphasis on the SPP protocols. I know that I reached out to SPP on several occasions on this very matter, And what I got was a very cursory, this is the company's discretion. We like to have foreknowledge of what's going to happen.
So in your opinion, violation of the SPP protocols regarding notice of retirement just wouldn't be a big deal?
That's the understanding I got from SPP.
Are you familiar with the retirement of Evergy's Sibley Unit 3?
Yes, I am.
The retirement date I saw in filings was November 3rd of 2018. Does that sound right to you?
That does sound correct.
But that wasn't the date when energy was last generated at Sibley, correct? That was sometime prior to November 13th of 2018?
Yes.
So what is the difference here? Why OPC would sometimes look at the date energy was last generated, but other times would look at what the company views as the retirement date?
I guess I'm confused with the question, Ms. Carter.
Well, as you know,
In both cases, my understanding is we are being consistent across the board. Both plants were did not have the ability to generate capacity during those times. And that was based off of affirmation through discovery and follow-up. I feel like the office has been pretty consistent. And again, if we want to bring up OPC witness Robinette, I would encourage that because he has done a lot of work on this.
But so it's your understanding that from public counsel's position, a plant retires, you look back to the last date it produced energy as opposed to the date that the company believes it was retired, when it stopped having staff there, when it intended to retire the plant. You think you should look back when it actually last generated energy?
Again, I'm going to say witness Robinette, who happens to be right here, is a good witness on this issue.
Thank you, and I appreciate that. I was asking the questions because your testimony says that Liberty shut the plant down in December of 19.
Yes.
On page 20 of your rebuttal testimony, you state that Asbury could have been sold with sales price offsetting other costs.
I did.
You're familiar with Drew Landell's direct testimony in the Asbury securitization docket?
I'm not.
You're not? You didn't review Mr. Landell's direct testimony in securitization?
I did not.
So when you filed your rebuttal testimony, you weren't responding to Mr. Landell's direct testimony?
Are you asking for Mr. Landell's which testimony? The direct?
Yes, his direct testimony in the Asbury securitization docket, EO-2022.
I'm not explicitly replying to Mr. Landell's testimony in this.
So you weren't aware of the fact that direct testimony in the case provided an estimation, a fair market valuation report on Liberty trying to sell Asbury and what that valuation was?
I am familiar with that number from the last rate case. I'm familiar that at least an estimation was done.
And that was that there was a value that was actually negative 134 million, that we'd basically have to pay someone to take Asbury as opposed to receive money from them for Asbury.
I think the timing of that valuation is pertinent. It's important in the totality of everything that we're talking about here. It's a sequential issue. So what I mean by that is the value of a baseload coal plant has increased significantly since that evaluation took place.
Since Asbury was retired?
Since the evaluation took place. My understanding is the valuation took place. Now, I can't speak to that. I don't know the timing of exactly when that valuation is in relation to the 12/12/19 retirement.
When do you believe the significant increase in value occurred?
As more wind came on to the SPP footprint, basically more baseload generation retired. And effectively you have the markets responding to more volatile prices. culmination of several things. For example, and one of the reasons we're here today, Storm Uri.
But can you tell me if that was before or after Asbury was retired?
Before. Very much so before. I mean, that's outlined in my testimony in the customer savings plan at length.
So what do you think Asbury could be sold for today?
Well, it doesn't exist today. You know, at least not in a position where it could operate without compromising your existing generation. What could it be sold for today? It would be speculative on my part. I know my research on the issue of this, and you know, my testimony outlined Xcel Energy as an example. That's just one rudimentary example. I know that there's been independent owners that have looked at cleaner, efficient coal plants in terms of, you know, Bitcoin mining and others that would seem to fit the Asbury model quite well. Empire would need to take in consideration that if a plant was up there, that would be potentially at the expense of their own wind investments.
Public counsel, or you personally, didn't perform a fair market valuation on the potential sale of Asbury before it was retired, correct?
We did not.
Or after it was retired, correct?
No.
Dr. Mark, do you have any experience operating a coal plant?
I do not.
So certainly not experience operating a coal plant that was built in 1970?
And then retrofitted more than twice its value in 2016?
No experience in those areas, correct?
Neither one.
You're not a certified operator.
I am not.
Are you an engineer?
No, I'm not.
Do you have any experience assessing the sales value of a 1970s coal plant?
That's been retrofitted, more efficient, and at a greater value than when it was created in 1970?
Either way, do you have experience assessing the sales value of a coal plant?
No.
At page 20 of your rebuttal testimony, you state that Asbury could have been mothballed. Is that correct?
That's correct.
But it's OPC's position that Liberty shareholders should bear all costs in that situation, correct? That customers would pay nothing for Asbury while it was mothballed?
It's OPC's position that ratepayers should not have to pay 3 times the usable capacity that was available.
And I'm sorry, Dr. Mark, if you could answer me a yes or no, and if you can't, just tell me. But first, if you could give me the yes or no, if that's possible. Is it OPC's position that customers would not pay anything for Asbury while it was mothballed?
Yes.
Are you aware of any time that a regulated utility has mothballed a coal plant and continued to maintain the operational status of that plant for a possible future event?
Xcel Energy.
And was that done at shareholder expense?
You know, I'm going to step back. I'm not sure Xcel is the only example. Give me a second. This becomes a bit of a difficult question to answer because most of the historic mothballed generation is going to be subject under the deregulation with deregulated states. Is where you're going to see that most pronounced, where market actors went ahead and, for a variety of reasons, mothballed plants because of operating expense and then opened them up again. As far as earning a return from an investor-owned utility from ratepayers, my understanding is that it's a bit of a mixed bag based off of my research. Some commissions have, there's a prudency argument and there's a used and useful argument. In our case, you know, we believe both apply to this situation.
On your rebuttal testimony, page 21, line 4, you are asked if there could have been options other than selling or mothballing Asbury. And your response is, I am sure there probably were. However, based on my discovery with the company, Empire Management did not even explore the options I articulated above. Is that correct?
That's correct.
And those options you articulated above would be selling and mothballing.
Yeah, I guess mothball is sort of a blanket term. Sure.
Okay, but so you're saying that, from your understanding, Empire didn't consider selling or mothballing? That they didn't consider those options, let alone considering anything else?
Not seriously, no.
And in Drew Landell's direct testimony, as we mentioned, he discusses the market study that was done regarding selling Asbury on the open market to another owner-operator. And that was in his direct testimony, in this case, filed before you filed your rebuttal, correct?
That's correct.
And his direct testimony also discusses the options of repurposing assets, abandoning in place, and demolishing, correct?
I'll take your word for it.
Looking at your rebuttal testimony, page 26, lines 14 to 16.
I'm sorry, page 26?
Yes, rebuttal, page 26, lines 14 to 16. You say that Empire's management assumed the risk of stranding Asbury, and I quote, so that it could utilize Asbury's SPP interconnection lines for its intermittent North Fork Ridge wind farm. Is that your testimony?
That is.
But North Fork Ridge has its own interconnection, correct? There was no transfer of an interconnection right from Asbury to North Fork Ridge.
My understanding was it was the interconnection line. There was some auxiliary operating capital investment on Asbury that's being utilized in conjunction with that wind farm.
So you weren't aware that in terms of the physical facilities, and again, this is separate from transferring the interconnection right that we just talked about, that was separate. But then in terms of the physical facilities, the North Fork Ridge Interconnect didn't use any of the Asbury lines. You weren't aware of that?
This would come as a surprise to me, and perhaps I'm getting hung up on it's just the interconnection line. So am I to understand that nothing from Asbury, none of the capital investments that are associated with that are being used to help operate the North Ridge wind farm?
No, I was asking about your statement on the interconnect lines. That you say the company stranded Asbury so that it could use Asbury's interconnection lines for North Fork Ridge. But so you weren't aware that that wasn't done?
My point, then I would revise my statement to say that there are certain capital investments at Asbury that were utilized at that North Ridge farm.
Those things that in Liberty's testimony we talk about having been repurposed. Is that what you mean? So you are aware that a utility or a service provider can seek an additional interconnect at or near a facility that already exists, correct? There's nothing that requires only one generation interconnect at a certain location.
There would need to be some, additional SPP studies to determine congestion issues associated with having more than one line operating there.
But for example, we have Kings Point, and Kings Point is interconnected at the same substation as Energy Center, correct?
That's correct.
And Energy Center has more generation than Asbury did?
Energy Center, yes.
And Kings Point, interconnected at that substation, same substation as Energy Center, actually has the highest LMPs of all the new wind farms, correct? Those have the highest locational marginal price?
Of Empire's wind farms or all wind farms?
Yes,
in
of the three
SPP?
wind farms.
Yes.
So that's where Kings Point is interconnected at the same substation with Energy Center. It still has the highest LMPs.
Okay.
All right, if you will please look for me, we're going to move to your Surrey rebuttal testimony. Page 2, lines 23 to page 3, line 3.
Where am I starting?
Page 2, line 23.
Okay.
And you state that it is possible that Asbury could be exposed to new, greater environmental risk in the future. And that if that happened, then management would have to examine its options and weigh the costs and benefits of compliance against early retirement. Is that your testimony?
That is.
And then you continue on page 3, lines 2 and 3, that there was no cost prohibitive environmental, air or water or other regulation that necessitated the premature retirement of Asbury. Is that correct?
That's correct.
So what time period, what future time period were you referring to there?
It's a hypothetical statement made out into the future, let's say over the life of that plant.
But that you didn't see any cost prohibitive costs coming up in 2018, 2019, the time 2020, when Liberty was determining whether or not it was the right decision to retire Asbury?
Let me stress that there are two things that I looked at in making that statement. The first is, what's the existing air quality and environmental regulations, or what's the status of the current play in Jasper County, Joplin, greater Joplin area? To inform that, I leaned on resources like the American Lung Association's State of the Air report. It's a 2020 report. It identifies clean cities, clean counties across America. Of the cities identified in the state of Missouri, of the counties identified in the state of Missouri, Joplin, Missouri, only one. And it's a 2020 report, but it's reflecting 2016 through 2018, when Asbury's operational. So the American Lung Association, pretty verifiable group that's going to mission statements got to be looking in terms of air pollution, identified where this coal plant operates, this efficient, this environmentally, and we put in hundreds of millions of dollars in terms of AQS scrubbers. That's the basis of me saying I don't foresee any initial hypothetical large-scale investments associated with further retrofits that are taking place. And I think I said in my testimony before, I'm aware of no environmental regulators that have come up and publicly stated that Asbury needs to be shut down because it's not clean, because it's exceeding some sort of air quality limit at this point. I had a second point, and I forget it now. It'll come to me.
That's okay. I'll editorialize, yay Joplin, yay Empire and its operators, good job, while you're thinking of your second point.
I think the second point probably means, hopefully yay customers that they don't have to pay for that additional cost, right?
Okay, there we go.
Okay.
But that was on the hypothetical end. But in terms of actual costs that were being faced by Liberty, you are aware, and it's in our direct testimony in this case, that Liberty was facing costs of approximately $20 million for a new landfill and a wet to dry bottom ash handling system conversion in order for Asbury to remain compliant with the CCR combustion residuals rule and the steam electric power generating effluent guidelines, the ELG rule. They were facing that $20 million in additional costs.
And I do reference that in my testimony. Again, context is important here. $20 million relative to what ratepayers are already being asked to bear, and what we've seen here is how things have played out with Storm Uri. It's in my rebuttal testimony, but I did acknowledge that there are additional. I think I coined it, well, give me a second. I'm on the stand. Yes, page 2. Lines 10 to 11. So were there avoided cost benefits? Yes. Empire avoided some coal ash handling costs, but these are relatively minor.
And that was the $20 million project you're referring to?
I am.
You made an edit to your testimony, and I have a question on that issue. Rebuttal, page 3, line 25 to page 4, line 16.
My edit was page 4.
Yes, and I'm sorry, my question's actually not about your edit.
Oh, okay.
But that testimony, that topic, so starting on page 3, line 25 of your rebuttal, and then continuing on to
Got
page 4, line 16, you talk about what you see as a one-for-one replacement contemplated by the securitization statute, correct?
Yes, that's correct.
But that portion of the statute isn't applicable in this proceeding, correct? Because Liberty hasn't sought approval of replacement resources under subsection 1705, correct?
It's because Empire's already been granted more than 6 times over that replacement value.
The wind projects are already in service and already in rates, correct?
Right, the 6-for-1 value. If it's any other additional securitization, a normal securitization doc, it would just be a 1-for-1. So my point there is that shareholders are being made more than whole in this situation.
And Dr. Mark, I'm sorry, when you say a normal securitization proceeding, this is actually the commission's first securitization proceeding, correct?
Let me qualify that statement and say a securitization where that section would be applicable.
Okay, so in a docket where 393.1705 was at issue, but that's not at issue in this case, correct?
Right, because Empire has spent $1.2 billion that ratepayers are covering.
Because we are not seeking approval of replacement resources in this case, correct?
That's because you got the replacement value.
Dr. Mark, I am so sorry. If you can just give me a yes or no. We didn't ask for anything under 393.1705 in this case, correct?
I'm not an attorney, but my understanding is that legally you can't do that. I think there's a cutoff date for that.
Okay. It's not at issue in this case.
I would contest that. I do believe it's an issue in this case.
You believe section 393.1705 is at issue in this case?
I believe that section provides a North Star for what the General Assembly felt was a fair outcome.
Of an application that's not filed under that statute?
Seeking energy transition cost. Yes.
Thank you, Dr. Mark. That's all I have.
Thank you.
All right, we'll come up for questions from the bench. Any questions from the commissioners online?
No questions, Judge.
Was that,
No questions, Judge.
I believe that was Chairman Sylvie first, and then Commissioner Holtzman? Is that right?
That's correct.
Okay,
That's correct.
thank you. I'm just trying to make sure we get the transcript correct here. I don't have any other questions either, so there's no need for recross. Any redirect?
Yes, thank you. Nathan Williams. Dr. Mark, do you recall being questioned about the dates for accounting authority orders between Sibley and Asbury and Public Counsel?
Yes.
Position? Did Sibley stop operating for the same reason Asbury did?
No.
Do you know what occurred at Sibley versus what happened at Asbury that caused them to cease operating?
My understanding is that Sibley experienced a malfunction in its system. In one of its, there was a malfunction in September of that year. I can't remember the year off the top of my head. The last rate case.
Did the Evergy immediately decide what to do with that plan upon that malfunction, or was there some time lag there?
There was a little time lag.
And do you know why Asbury ceased operating?
For the reasons articulated in my testimony.
Lack of fuel?
That's one of them.
No further questions, thank you.
All right, then, Dr. Mark, you can step down.
Thank you.
The only other witness available for today would be Lena Mantle, and she's not here at this moment. So let me ask the parties, do we want to come back this afternoon to do Ms. Mantle, or do we want to wait till tomorrow to do her?
If you can, that would be appreciative. She's part-time.
Oh, to wait till tomorrow, it's
No,
easier?
today.
Oh,
Do it
yeah,
today.
we're totally fine either way.
Is that okay with everybody? Okay, we'll come back at 1 o'clock with Ms. Mantle. And at this point, then, we are adjourned until 1 o'clock. Thank you all. we will resume for a moment. And I understand that Ms. Mantle, the witness who's next on tap, is not available yet, and anticipated that she will be able to be here by 1:30. Is that right?
That is correct. This is Nathan Williams for Public Counsel.
All right. We will therefore recess the hearing again until 1:30, and we'll come back at that point with Ms. Mantle.
Thank you.
Thank you.
licenses do you have this afternoon?
Just one left.
Oh, this is the only one?
Yeah, yeah. We talked about having Dave Murray come in from OEC, but, I think, Dean Cooper is gonna be presenting her, and he's done for the day, so.
Okay. Yeah, just curious, I think I'll hopefully be able to contact those folks and get a test in for tomorrow, this afternoon.
Cool, perfect. Yeah, I
Yeah,
was
so-
gonna check with you on that,
Yeah.
make sure it was, I was like, I don't want to, we don't need, the high paid
No,
consultants doing
no,
tests,
no,
we
no,
just
no.
need.
No, just to test, yeah. Yeah, you said it, you needed it, I was running around, but thank you for being eloquent and saying just what we need to test. I just wanna make sure you're there,
yeah.
we can talk and
Make
that's,
sure, yeah,
take a couple minutes.
Audio, the microphone works, the camera works.
Yeah, everything.
You can hear it, software's all up to date.
You know, yeah,
I've done that where like go to Zoom call and it's like, Zoom would like to update, 30-minute update.
Yeah, yeah. That's why I keep trying to tell people is that, you'll avoid so many problems if you just sit at the computer just the day before or 30 minutes before and find out. And in fact, John, during the trial, just sent me a note that the agenda is going to be computer this afternoon. So everybody's going to need to re-log on.
Yeah.
It's always one of those things like, hey, you got
An update. And
Yeah.
set it up.
Yep.
Yeah, what do you call it? For like federal courts, and I know most state courts that are tech equipped now have mandatory, like the day before, a week before, you bring in your equipment, plug it all in, make sure it works.
Yeah. Nice.
That way, that way the jury's not sitting there like,
Yeah. Yeah.
that's the part they don't show in law or they'll like sit
Yeah.
around waiting.
Yep. It's all part of it.
I'm gonna go use the restroom, run some extra work down to,
Yeah.
do something more.
Yeah, I know, right? I just remembered I need to shut this camera off over here. Back up, court reporter over here.
Anytime this evening is better for you. Call, question mark.
Yeah. It's fine. Exactly. Oh, really? No. So they'll be there. Oh, they're gonna be there. Yeah. Gotcha.
Yeah, I'm like, how is it I've managed to not finish anything? But start them all. I have, and I thought I was gonna get it, and then I ran out. I did drink a lot of water at 9 cents, so I did get it. I actually only get, I only drink that much water. That is true. I don't know how my kidneys still function. Not that I'm drinking alcohol, but I really was sober. That's how you're okay, is that you're not doing the bad stuff to your kidneys, I guess. Not one really appreciates Pepsi as much as I do. I still don't understand how soda isn't water, since it's mainly water. It's got a lot of sugar. Yeah, but like, doesn't take away the, yeah. The base is still water. Somebody had a base for us one time, like when I worked in the hospital. They gave us a wellness thing, wellness coach. And so we had to go and meet from, meet really insurance. And he, I remember him saying something about like, the caffeine that's in it actually affects your body. And so that's why it's kind of, it's all said so. Yeah, whatever. You can tell from my habits today, whatever I was told was very effective. But your insurance premiums were lower. Yeah, it was at the time. Yeah, we're bad, we don't even do those. I have yet to figure out what Eagle Doctor was to, as a business partner. They actually do really well, and since I actually worked at the insurance company, we could see the trends because I don't know, I'm not. well, that's why I felt it was very much work with, insurance proceeds every day on the coach. Yeah. Oh, yeah. Did you guys resort? I'm trying to get a lot of it. It wasn't a meeting, it was just discussion. But, should be something. Yeah, very good tariff. If it's questions for me, hang
Yeah, I did pass. Thank you. Sorry about the delay. I appreciated having a chance to catch my breath.
we're back on the record. It's 1:30, and Ms. Mantle is here, and we're ready to proceed. If you please raise your right hand, do you solemnly swear or affirm testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may inquire.
Nathan Williams for Public Counsel. Good afternoon, Ms. Mantle.
Good afternoon.
Would you please state and spell your name?
My name is Lena M. Mantle. Lena is L-E-N-A. Mantle is M-A-N-T-L-E.
Ms. Mantle, did you prepare and cause to be filed in question and answer format rebuttal testimony that's been marked for purposes of, as an exhibit in this case, 200, and surrebuttal testimony, which has been marked as Exhibit 201? And when I said case, it's actually two cases, but is that correct?
That is correct.
And then did you later pre-file a couple additional schedules to rebuttal testimony that have been marked as Exhibits 202 and 203? And I believe they're basically Schedules 7 and 8 to your rebuttal testimony?
Yes, Schedules 7 and 8 to my rebuttal.
Do you have any changes to any of those exhibits for them to be your testimony here today?
I have one change in my rebuttal testimony. On page 24, line 7, I have that Empire needs to have accredited capacity 112% greater than its forecasted peak. That should be 12% greater than its forecasted peak.
Do you have any other revisions?
No, I do not.
And with that change, are Exhibits 200, 201, 202, and 203 your testimony here today?
Yes.
I offer Exhibits 200 through 204.
It'd be through 203.
I'm sorry, you're correct. I apologize. 200 through 203.
200 through 203 has been offered. Any objections to its receipt? Hearing no objections, they will be received.
I tender Ms. Mantle for examination by others.
All right, and cross-review with staff.
Thank you, Your Honor. Kurt Stokes on behalf of staff this afternoon. Ms. Mantle, were you here yesterday for the examination of staff witness Jordan Hull?
Yes, I was.
Okay. Do you recall a question about a list of Empire resources in the integrated resource plan?
Yes.
And can you turn to page 18 of your rebuttal testimony at table 2?
I'm there.
Is it your understanding that the 2019 IRP, that side of that column of the table, is that Liberty's most recent integrated resource plan, or?
They may have one filed right now, but at the time of this proceeding and the cases before it, these were the resource plans in question.
Okay, and the numbers in that table, that reflects the capacity for each unit in megawatts?
Yes.
Okay. The next thing I want to talk about is the 95.5 sharing mechanism. Is it your understanding that when Liberty filed its 2021-0332 fuel adjustment case, that it sought to pull out certain costs it described as extraordinary out of the FAC?
Yes.
And OPC raised a concern about where you set the level of what qualifies as extraordinary or not.
Yes, we did.
What was OPC's position in that case?
That minds could differ at where that break point was between ordinary and extraordinary, and and we also have the whole responsibility of trying to keep customers' bills low. I looked at what the highest one measure of extraordinary versus ordinary would be what the highest amount the rate had ever been. And that would have come up with a FAC rate of, I think, 7.47 cents, or about $7.50 on a 1,000 kilowatt hour basis. The commission at one time had said that was okay, so that could be ordinary. And of course, the benefits to that is that money, I think it was a 23.5 million, that would not have been considered extraordinary. Then that would have that would have been recovered from customers quickly. And there would be less to be recovered through. At that time, it was an AAO because we didn't have securitization yet. So that would be monies that would be collected from customers within 6 months. Short-term interest rate on that, instead of being either in an AAO or in this case securitization, where the company's asking for their weighted average cost of capital to recover that amount over 13 years. So it's like taking out a loan for 13 years. You end up paying more than, a lot more than your initial amount. So, but at the same time, that would mean bills went up higher. So we were really sort of ambivalent as to where that break point was.
And are you familiar with Liberty's currently pending accounting authority order filing, requesting it's a separate case, but it's requesting recovery of Winter Storm Erie costs, or an AAO for Winter Storm Erie costs?
I may have read that a long time ago. I really don't remember much about it.
Okay. Do you remember a request that Liberty made asking the commission to make to include something in its order about making sure that they would recover the amount?
If I'm remembering correctly, there were two buckets. There was the amount, the 95%, and then they were also asking for the 5% to be recovered.
Okay. Let's raise a hypothetical. Let's say, in this case, that Liberty is ordered to recover 100% of its extraordinary costs in Erie. Are you with me so far?
Yes.
Okay. Now, let's also imagine sometime in the future some other major event like Erie happens. It doesn't have to be Liberty; it could be any utility. And the commission is again asked to defer certain extraordinary costs. What is OPC going to have to do in its calculus to figure out, okay, how do we figure out what costs are extraordinary and what are not? You had mentioned earlier some considerations of rate shock, but also considerations of, not sharing in the 95.5.
Of course, you're asking me what OPC could do, and I am not OPC, and I can only speak for myself. I would look at, again, what customers had paid, and knowing what came out of this case, because that will make a difference. And did you start the hypothetical off with they get 100%? Mm-hmm. If they get 100%, if they get weighted average cost of capital, I will push for more to be considered ordinary than extraordinary, knowing that the customers then would pay for it quickly, lower interest rate, so a lower total amount coming from the customers.
Would it be difficult to find a dividing line between what level of, increase in that FAC customers would be willing to stomach?
It would. If you're looking at a time such as we have now where gas prices are higher than ever been seen before, inflation is just skyrocketing, a rate increase has just been started for the customers. It may be a bit lower than if, prices were stable and we weren't in a period of inflation. Rates just hadn't gone just up. There's a lot of factors to be considered. Also, what what have customers paid in the past? And I will say right now, I looked yesterday, for 1,000 kilowatt hours, customers are paying $12.21 on Empire's FAC. So that bar of ordinary to extraordinary, right now, the commission has said a much higher amount is ordinary and can pass through the FAC Empire, and that's what Empire requested. So all of that would have to be looked at and considered.
Now, let's reverse the hypothetical. Let's say that Liberty's, ordered a 95.5 sharing. Does that decision get a lot easier on how you divide the line between extraordinary and not extraordinary?
I don't know. And I should have been ready for this question, but you got me, Curtis.
Sorry.
I think that knowing if it can't, knowing that the customers would not have to pay, that 5% would mean be a little more lenient in what is considered extraordinary. But it also have to consider the way what the interest rate was that's being attached to what is extraordinary and how much time they wanted to collect these extraordinary costs over.
Okay, and I guess I should emphasize that the question was, is it easier, not is it easy?
It would be easier.
Okay. So in the event that there would not be cost sharing under securitization, is it fair to say that customers would have to be looking at the trade-off between not benefiting as much as they could under the securitization statute because of the lack of that 95.5 sharing, and that's part of the consideration?
Can you repeat that question?
Yeah, that was awkwardly phrased. So would it be part of your consideration that if a utility was seeking 100% recovery of extraordinary costs, that there is some trade-off involved with securitization as far as like not having a sharing but still getting some kind of lower cost of borrowing?
Yes.
Yeah. And is it your understanding that the intent of the securitization statute is to force that kind of trade-off on ratepayers?
I have not read the statute, so I cannot speak to that.
Okay. Would it be your preference that the statute be used to save ratepayers money, not to force them to make trade-offs?
Yes.
Okay. Let's switch now to Asbury. Was Asbury up and running during Winter Storm Uri?
No, it was not.
Were ratepayers paying for Asbury during Winter Storm Uri?
They were paying return on and of. They were paying O&M. They were paying for coal cost. Yeah, they were paying for Asbury.
And in your opinion, is it just and reasonable for ratepayers to have paid the full cost of Asbury when Asbury wasn't there during Winter Storm Uri?
No.
Will Asbury ever again serve Liberty customers?
No.
Is Liberty asking its ratepayers to continue paying for Asbury for the next 13 years?
Yes.
In your opinion, is it just and reasonable for Liberty's ratepayers to pay for the full cost of Asbury when Asbury's not there to serve them?
Can you say, I want to give the correct answer. What was the first part of that question?
In your opinion, is it just and reasonable for Liberty's ratepayers to pay the entire cost of Asbury while Asbury is not there and used and useful?
No, the public has sort of a compact with the utility, expecting the utility to provide a service for them at just and reasonable rates and provide adequate and safe, reliable. And by asking customers to pay for, the AQCS, and then only getting 4 or 5 years of benefits out of that. They made a compact with the customers. You pay for this, we'll provide you good, clean, electricity for another 15, 20 years. They broke that contract when they retired that plant. And so now for them to ask customers to pay when customers are not getting the full benefit of that, I don't think that's just and reasonable.
Okay. Now, I know in your testimony you recommended some prudence disallowances for Asbury, right? Or for resource planning.
For resource planning, yes.
Setting that aside, or would you be opposed to staff's proposal for a cost sharing between Liberty and its ratepayers for Asbury based on the used and useful principle?
I'm not comfortable enough with what staff's position is with that to have an opinion.
Okay. No further questions.
All right. For Liberty.
Thanks, Judge. Ms. Mantle? I'm going to start with something staff counsel asked you. He put the hypothetical to you on if, in this securitization proceeding, Liberty were allowed to securitize 100% of the what's been deemed extraordinary fuel and purchase power costs. And I believe you said it would be easier for OPC, looking in a future FAR docket, fuel adjustment rate docket, to find that line on what's extraordinary and what's not, that it would be easier if Liberty didn't recover 100% here. Is that correct?
Yes.
I'm assuming you'd agree with me then the exact flip is true for the company, that it would be easier for the company to make a decision on what they would deem extraordinary or seek to have deferred from the FAC clause if the trade-off was you aren't able to recover 100% of the costs, but you're also not recovering them over 6 months?
I can't speak for the company.
You wouldn't agree that would put, much like you're saying, it would put you in a harder situation if 100% is recovered? You don't see that that's what would be reasonable from the company's standpoint, that they would both not recover over 6 months and not recover 100%?
I'm sorry, I really don't understand the question well enough to speak, and I don't want to speak for a utility either.
Okay, that's fair enough. On the hypothetical, again, that Mr. Stokes asked you about, you said it would be forcing customers into a trade-off, I believe, between either having recovery stretched out or not paying that 5% above what is in fuel costs, base costs, is that correct?
Not only time, but also it's according to what interest rates put into that securitization amount. But yes, there is a trade-off of recovering over time versus rate impact over a 6-month time period. I think that's the question you were asking.
Yes. And so then that would apply equally on receiving the payments when the company's already paid for the cost of fuel and purchase power?
The cost of fuel and purchase power is, while it's not completely under the control of the utility, it does have some control. And at the, a lot of what my rebuttal testimony is, it's decisions on resource planning, it's decisions on what goes on in the SPP, and there, on the other side, customers, there's a lot of them living paycheck to paycheck. And you want to take out of their paycheck for 13 years or 6 months. There's a lot to balance there. And, the commission has been asked to do that balancing. And OPC is, we represent the customers.
And ultimately, no matter what happens here, just like in Liberty's FAR filing immediately following Storm Uri, the commission ultimately will still need to do that balancing and make the decision in subsequent FAR filings. The commission ultimately gets to decide where that line is on extraordinary, correct?
That is correct.
I'm going to reference your rebuttal testimony. I believe you have that with you.
Yes, I do.
I'm looking at page 3, and you state that you are experienced in electric utility resource planning in Missouri, correct?
Yes.
Have you participated in Liberty's resource planning dockets at the commission since you joined public counsel in 2014?
Marginally, not the way I was at the commission when I worked for the commission staff.
So since 2014, you have only been what you would call marginally involved?
In the resource planning dockets, I was very involved in the 2018 case for the customer savings plan. I was very involved in the CCN case, written testimony then for the last rate case too. So I have been involved, just not so much, not deeply in the resource planning cases.
And there's been an IRP docket, either a triennial or an annual update every year, correct? That is the process at the Missouri Commission. There's either a triennial or an annual update every year?
That's correct.
And to your knowledge, was Asbury addressed in all of Liberty's IRP filings?
When you say was Asbury addressed, can you define that a little better?
Yes, the Asbury coal plant was part of the resources being considered in each of those filings.
I'm going to object to that as to being vague as to the filings. If you want to put a range of dates or say it was every IRP that Liberty's ever filed, that would be helpful. But
If you could clarify your question, please.
Yes, and Ms. Mantle, I was still referring to the ones we had just discussed. Since you joined OPC in August of 2014, that there has been a Liberty Empire IRP docket every year since then. And if you don't know or don't recall, that's certainly fine too.
As shown in the table 2, my table 2 on page 18 in my rebuttal testimony, I show what the current position of Empire's is with respect to its resources, and then what was in the 2016 resource plan and the 2019 resource plan. In the 26 resource plan, the AQCS had just recently come online. At Asbury, it was considered a resource. And then, as you can see, and I discuss in my testimony, in the 2019, of which it was the only resource that was allowed to retire, the resource plan said retire it. And I discussed that in my testimony. So the resources you have now are fairly consistent with what the 2019 was that does not have Asbury included. Once the Asbury plant goes down, it's no longer included in any resource plans.
Schedule 2 of your rebuttal testimony is a document labeled Resource Planning of a Vertically Integrated Utility in the RTO World, correct?
Yes.
And that is what you call the white paper authored by you, is that correct?
That is correct.
And to inform you in the preparation of the white paper, you did not attend any meetings of working groups, advisory groups, task force, or other relevant meetings in either SPP or MISO, correct?
I don't know what relevant meetings are. This goes back to the very basics of an RTO in a marketplace. To be accurate to do that, you'd have to go to every single one of the meetings, and no, I did not. These are conceptual. I don't specify SPP, I don't specify MISO, I don't specify PJM. It is just a generic, here's how it works now in the resource planning.
Ms. Mantle, when you were asked in the data request to provide a list of all meetings of working groups, advisory groups, task force, or other relevant attendance in either MISO or SPP, you simply answered none, correct?
Correct.
Turning to your rebuttal testimony, you have that with you also?
I do.
Lines 11 through 13.
Of which page?
Oh, I'm sorry about that. Page 4.
Okay.
You recommend that the commission not authorize total recovery of the storm costs because you contend Liberty was imprudent in its resource planning process, correct?
Yes.
You acknowledge that Storm Uri prices were, I believe, 100 times higher than the average SPP market price. Is that correct?
I think it was more like 1,000.
Oh, okay. Do you believe it would be prudent or even realistic to test a portfolio's efficacy using prices that are 100 or 1,000 times greater than normal?
Yes, I do.
You do?
Yes, that tests the robustness of a resource plan. It may not be what the resource plan is based on, but it will show how the resource plan meets those kind of conditions. A resource plan is typically a combination of several scenarios, different load forecasts, different market prices, different gas prices, and they're all attached to probability, and it's a expected value. And it's one thing that I learned in college. You have something with a low expected value but a big cost, it can influence the final result.
Utilities are sometimes accused of gold plating. Are you familiar with how that term has been used? Thank you, Siri.
Yes, I'm familiar with that term.
I don't know whose phone is recognizing my voice, but would it be gold plating, in your opinion, to design a generation fleet for every possible, although incredibly unlike new peak or extreme prolonged temperature?
It would be unwise. I don't know if I'd characterize it as gold plating, and I would probably say that was imprudent also.
Looking back to your rebuttal testimony, on page 4, give you a second to get there. Looking at lines 17 to 19, it's your position that Liberty designed its resource portfolio to, quote, beat the SPP market, correct?
Yes.
Does that reference to beating the market include include Kings Point, North Fork Ridge, and the Neosho Ridge wind farms?
Yes. But it also includes taking down Asbury.
One question first on the wind part. You'd agree with me that the commission issued certificates of convenience and necessity for the 3 wind farms, correct?
Yes, but as I stated back in the back of my rebuttal testimony, that doesn't mean they have to be built. There's been other CCN granted for generation where the generation was not built. Probably the most obvious one is Callaway 2 is not built, but yet a CCM was granted for it.
But you'd agree with me that the commission granting the CCNs means that the commission found it would be in the public interest for those wind farms to be built?
At the time that and based on the information that was given them, yes.
And as you noted, your reference to beating the market was also applying to Asbury. OPC never filed a complaint against Empire or Liberty related to the operation of Asbury, correct?
No, when it was running, it was an efficient unit.
And prior to Asbury's retirement, OPC never sought a disallowance based on alleged imprudence of how Empire or Liberty operated Asbury, correct?
No, that is not correct. We never asked for a disallowance. We asked the commission find it imprudent and that for the wind projects to be built and for Asbury to be retired. That would be in case EO-2018, I think it's 0092 in my rebuttal testimony.
And just so the record's clear, I think it was a yes to my question, but I'll ask that again. Prior to Asbury's retirement, OPC never sought a disallowance based on alleged imprudence of how Empire or Liberty were operating Asbury. Is that correct?
That's correct.
With your rebuttal testimony, you respond to the direct testimony of Drew Landau, correct?
Could you provide the reference of what page?
Well, and I wasn't on a specific portion, but you're critical of Liberty's decision to retire Asbury, correct?
Correct.
And Mr. Landau, in his direct testimony, provided his testimony regarding why Asbury was retired, correct?
I do not specifically remember who filed that testimony.
Are you aware that it is Liberty's position that Asbury was no longer economic in the SBP integrated marketplace? And again, I'm not asking about yours, but are you aware that that is Liberty's position?
Yes.
On page 19 of your rebuttal, excuse me, you state that Liberty retired the only coal plant that it controlled because the margin of the coal plant, because the margin the coal plant was making in the SPP market was not covering its fixed operation and maintenance costs. Are you there in your testimony?
Yes.
And you say that Empire now has no baseload coal generation resources that it has control over, and then your words, meaning that Empire does not participate in the decisions regarding hardening these plants for operation in cold temperatures or preparing the plants for operation during extreme cold. Continuing your words, these plants had their generation limited for a variety of reasons during Storm Uri, none of which were under the control of Empire. Is that your testimony?
It is.
Would you agree with me that you do not have concrete support for the position that Asbury would have performed perfectly under the difficult conditions of Storm Uri?
That is correct.
In the testimony passage that we were just reading, what plants are you describing when you say these plants? The plants that had their generation limited for a variety of reasons during Storm Uri?
It would be the plants in my my rebuttal schedule LMMR4C. It is a net fuel and purchase power report provided or submitted to the commission, and it talks about, and it is a confidential document. It talks about D-rates that there were D-rates on coal generation, and it talks about specific units and the problems that were at those units.
As far as the specific units you'd be referencing, would it be Iatan 1 and 2 and Plum Point? The other units where Empire has an interest but is not the controlling owner?
Those are the only coal resources you have once you shut down Asbury. So yes, those are the ones that I'm referring to.
And during Storm Uri, it's my understanding that Iatan 1 ran about 91% of capacity, Iatan 2 ran nearly 100%, and that Plum Point derated to 50 megawatts, I believe by February 12th, and then went offline. Is that your recollection?
I don't recollect the specifics past what is in this attachment to my testimony.
Do you recall that some did well and some didn't do well with the extreme conditions of Storm Uri?
Well, according to this report that's attached to my testimony, yes, there were some that did better and some that didn't do as good.
What is the purpose of emphasizing in that passage that we just read that Liberty does not have control over these other plants, quote, meaning that Empire does not participate in the decisions regarding hardening these plants for operation in cold temperatures or preparing the plants for operation during extreme cold?
Are you asking why I put in my testimony?
Yes, what was the point of, in your testimony, what was the point of calling that out, that Empire no longer has control for those specific things?
Part of meeting a customer's loads is to be able to say what generation can come on, what generation is not to be dispatched, when O&M is to be done, what kind of coal pile to have, the coal inventory. All those are decisions that impact how much energy is available to meet the customer's loads. When they are minority owners, Empire's minority owners of these plants, I've been told by Empire personnel that, you know, we don't have control over that. We don't know what's going to happen at IATM 1 and 2. We don't know what's going, you know, they know what's going on, but they don't have control over it. So they don't know whether it's going to be down for maintenance when Empire needs it, or what's, you know, they might know the coal pile amount, but they aren't directly in charge of making that decision.
Although Liberty would not have direct control over those decisions, for those 3 plants we mentioned, Iatan 1, Iatan 2, and Plum Point, another Missouri regulated utility would be the one making those decisions, to the extent decisions are made by the utility, correct?
Correct.
And for all of our regulated utilities in Missouri, the functional control has been given to the RTOs, SPP or MISO, correct?
Yes.
Looking at your rebuttal testimony, page 10, lines 9 to 11, you state there that, well, let you get there, sorry. You state that you have not looked closely at the inputs in the resource planning models Empire relied on to know how Empire may have manipulated the modeling to show Asbury would be uneconomic. That's your testimony?
Yes.
Now, we talked about the IRP dockets and that you were involved, at least to some degree, in all of those IRP dockets. Should you have looked closely at how Empire modeled Asbury in those dockets before taking a position in this docket on the prudence of retiring Asbury?
No.
You don't believe so?
There are tens of thousands, hundreds of thousands of inputs into these models hourly for 20 years. So that's 8,760 times 20 inputs. There's no way to look at it, but you can look at the results and see whether or not they seem reasonable. And I do know the one thing that was done was that to manipulate the model was only allow Asbury to retire. Don't look at the other generation plants to retire. And it would have to do, I don't know the O&M costs that were put in. There's so many inputs for every unit, there's absolutely no way I doubt that there's anybody at Empire that has looked at every data point that's put into these models. You know, the forecasts are put into the models by customer class, 8,760 for every year. There's absolutely no way to do this.
Thank you. That's all the questions I have.
Okay. Then we'll come up for questions from the bench. Are there any questions from the commissioners online?
No questions, Judge. Commissioner Holzman.
Thank you. All right, I do have some questions. And the first one is simply to define a term that was used in your previous testimony a few minutes ago. D-rates, can you describe for me what D-rates are?
D-rate, a plant can go down completely or partially. A D-rate is typically going down just partially. So the plant can generate, but not to its fullest capacity.
Okay, so it's declining in its rates.
It would decline in its efficiency, but during something like Storm Uri, every megawatt hour that could get out was
okay, and I believe you said
needed.
Plum Point derated by 50%, is that, did I remember that
Ms.
right?
Carter said that, and that's a plant that's in Arkansas, and I do believe they had some problems with their coal pile freezing, or I don't remember exactly what it was, but there was a derate.
Okay. Then there was some testimony from another witness about the self-commitment policies of Liberty as to the Asbury plant. Are you familiar with what I'm talking about with self-commitment?
Yes.
Okay. Do you believe that it would have been prudent for Liberty to continue self-committing Asbury?
That would depend on a lot of factors. It would mean that it likely would not be cost effective. As it was currently run toward the ends, it was on the market, just looking at the cost of fuel and what the revenues made in the market. They did make $4 million a year on this power plant, so it was marginal. But at the same time, operating at a small loss doesn't necessarily mean that it's bad. For example, they've got 2 wind PPAs that they're losing $1 million to $2 million a month on, and they continue with those PPAs. There's
Purchase power agreements?
Yes, sir. Sorry, purchase power agreements. So, and having Asbury would have given them a resource that they could move with the load, or ask SPP to. They could sell into market different values. Again, they do not dispatch, SPP does. So there's value other than just economic value. And self-commit looks at whether they should self-commit or not, looks completely at the economics of the market, not necessarily at, having a plant, open. So there's benefits to self-commit that are not necessarily market benefits, but benefits to customers. Self-commit does mean that there's periods of time, or when you don't self-commit, there's periods of time where that plant in the past would have been running, but now it's not. And so there's benefits to both ways.
Okay. Now, it's been suggested that Liberty should have planned more effectively for Winter Storm Uri by having Riverton 11 ready to operate with fuel oil. After the retirement of Asbury, which had a capacity of approximately 190 megawatts, what dispatchable capacity did Liberty have left?
If you turn to the table 2 on page 18 of my rebuttal testimony, the combustion turbines, Riverton, State Line, and Energy Center, Riverton 12, State Line, combined cycle, and the IATAM plants, Plum Point, those were all, you can dispatch those.
Okay.
The Meridian Way Wind is purchase power agreement, as is Elk River Wind. Ozark is a hydro. It's how much water is flowing. That's Lake Taneycomo. They make Lake Taneycomo down at Branson. So those, they do have quite a bit of dispatchable, but if you totaled up the amount that's dispatchable against the loads, it just wasn't enough. And they are supposed to plan to meet their winter peak.
Now, of these units with dispatchable capacity, did any others have the ability to use alternate fuels?
The Riverton units, as you've heard, I believe 2 of Energy Center combustion turbines can, and State Line CTs are dual fuel. They can run on either natural gas or fuel oil.
Should have any of this have an impact on how Liberty operated the Riverton 10 and 11?
Should any of this, what do you mean by that?
Well, we were just talking about units with dispatchable capacity and alternative fuel. Do you have any concerns about the way they operated 10 and 11, Riverton 10 and 11?
Empire is a dual peaking utility, which means they peak in the summer and sometimes they peak in the winter. They should have been prepared for a winter peak. I heard that they were tuned at 70 degrees. Well, that catches your summer peak. They're probably going to get that. But Empire was not prepared to use these for their winter peak. And during Storm Uri, when prices are $7,000 megawatt hour, any megawatt hour that could be squeezed out of anything, regardless of their fuel sources, was a valuable asset.
Okay. How many of the wind units were operating on January 1, 2021 of Liberty's wind units
On January 1
of 2021?
of 2021, I believe their North Fork Ridge wind project had been handed over to them. The other two were still in construction phase. They had some of their wind turbines that were working and some that were not. But even then, they weren't in rates yet. So absolutely no megawatt hour that was generated provided any benefit to the customer other than maybe keeping SPP up, keeping a blackout from happening. Other than that, they did not provide any revenue benefits to customers.
Can you explain that last statement about keeping SPP up? Were they able to actually use some of that power to keep the lights on?
SPP came close to going down, and so every megawatt hour that was put into the system kept that from happening.
So you're saying they couldn't sell it, but the power was going into the system?
They did sell it. The revenue from it went back to Empire's shareholders.
Okay.
Because it wasn't in rates yet.
Okay. And that, I'm assuming you're not saying that was an intentional decision on the part of, of Liberty, it just the way it was in the process?
And not just the process of this plant, but when IA-10 1 and 2 were built, the energy that was generated prior to it going into rates, that revenue was used to offset the capital cost of the plants. Empire rate case was a black box settlement, so we can't really say how much, whether or not it actually offset the capital cost, but that is typically the way it's treated for new generation, is up until the time the customers wouldn't see the benefit in their fuel and purchase power cost until it is in rates.
Okay. Talking about the balance between resource adequacy, capacity, and dispatchability and reliability versus cost effectiveness. Can you give me a range of appropriate actions that would have been expected by Liberty to take, that would have expected Liberty to take in order to balance providing reliable service with cost effectiveness of its generation units as it made its decision regarding the retirement of Asbury?
Asbury provided great value in being dispatchable and being there. It's often said that the wind projects replaced Asbury, which is that's like saying, a pineapple is the same as an orange. They're just two, neither one's bad. They just have different qualities. One cannot replace the other. And the wind projects are only reliable when the wind is blowing. And load doesn't always care whether the wind's blowing or not. It's there all the time. So wind is a resource that's good at offsetting other resources. It may be cheaper than, saying, running a CT, but the dependability is not there. So and it's not just Empire, but we need plants that we can depend on. Asbury was partly paid for, it was a very clean plant. We've got the American Cancer Society reports that show Joplin in one of the top 100 cleanest cities in air, and that was while Asbury was running. So it was a good plant, and you can't replace that with wind. It would be, you could replace it with another coal unit. You could replace it with, and with that you get high cost, initial cost, or you could replace it with combustion turbines. They're cheaper to build, but right now with the way the price of natural gas is, and the fact that we learned during Storm Uri that firm transportation natural gas doesn't mean you're going to get natural gas when you need it. So, I mean, all of these things need to be balanced. When you get too heavy in coal, then that's bad. You get too heavy in wind, that's bad. You need a good balance. And with bringing Asbury down, if you take that that was a given and that was the right thing to do, then for their customers' benefit to have reliable power that they know that they can flip a switch and it can be on, you would need combustion turbines or another coal plant.
Now, there was some testimony earlier in this hearing about the heat rate at Asbury. And I believe the company witness indicated that the heat rate at Asbury was the lowest of their coal-fired units. Do you disagree with that?
Heat rates are a funny thing. I think lowest means best, but it was not as good as the others, is what I think was what the testimony was, and I remember seeing graphs of heat rates at Asbury before and after the AQCS that was installed in 2014, 2015, and it really helped the plant to run more efficiently. Because they did more than just install the air quality control system. They did other upgrades and improvements to the plant that made it a more efficient plant. You know, different kinds of plants have different efficiencies, and it is a way to compare across plants. But Asbury was a clean plant. It was because of the additions, the money they're asking customers to pay right now, because that was spent. It was a clean plant with a better heat rate. It was a better plant than before they put that on there.
Okay. Can you explain to me what, does public council believe it's prudent for customers to pay 100% of Storm Uri costs through securitization as opposed to an AEO versus, or an AEO uses 95% of the same costs that would otherwise be recovered through the FAC? Is that, have I asked a coherent question there?
I didn't understand.
Okay.
It may have been coherent, but not to me.
Okay. I'll read it as it's written here. Does OPC believe it's prudent for customers to pay 100% of Winter Storm Uri costs through securitization or an AEO versus 95% of those same exact costs that would have otherwise been recovered through the FAC?
It's OPC's position that only 95% of the cost should be recovered. The commission has said that the companies need an incentive to act efficiently when it comes to fuel and purchase power decisions, and there were decisions being made on the fly during Storm Uri. I mean, it didn't say when everything is going well, then they need a 5% incentive. And you got to remember that incentive goes both ways. Evergy Metro, which made revenue above its costs during the storm, got to keep 5%. They flowed it through the FAC.
And why did Evergy Metro make extra revenue during the storm?
Because it had generation well in excess of what it needed, and that generation was up and running, and they could sell it at the market. Ms. Carter talked about the market prices being 100 times more than usual, but it was closer to maybe 1,000. And a coal plant, the coal is on the grounds, and if that's the fuel cost. That's what they're burning, and any margin they make above that off the market offset other cost. So they had a lot of generation sold into the market at very high prices So they generated a lot of revenues so that they could, even more than what the load cost. So because they had generation that was dispatchable, that had the fuel source down on the grounds, they were able to generate a lot more revenues than what the cost they incurred.
Is there a downside for ratepayers of having too much capacity for a company, having too much capacity?
There is, because remember that all that capacity is capital cost, and that's in their fixed base rates. And, you know, that's the whole reason that coal plant is expensive, a nuclear plant is expensive. And that's part of the reason why they're a natural monopoly instead of having, you know, a whole bunch of generation built out there and nobody can afford the capital cost. Then let's build this big plant. It has a high capital cost, put that into rates, but we're going to enjoy low fuel cost. We're going to get the benefit of a reliable fuel cost. And versus the other way around, you put in, let's say, wind, you've got your, and please don't take me as pro-coal and anti-wind. They each have their place in a resource portfolio. But with wind, you get a capital cost putting it in, and you make great revenues, but only when the wind's blowing. You can't count on that. So each of that needs to be balanced. If you put too much capacity in, rates go up because customers are paying for that. But then their fuel costs are lower. So it's a balancing act. That's what resource planning really is. It's balancing, or it was in the past, before the markets. It was balancing, trying to fit the best resources in to meet the customer's load cost effectively. So you didn't want everything to be base load. You didn't want everything to be CTs. You didn't want everything to be wind. You fit it to the customer's loads.
Okay. And you said that before markets. What's the situation now with markets?
Now, and it's not just Empire, but the utilities see SPP as an unlimited resource for energy. So if their resources aren't there to generate electricity to meet their customers' needs, the market will supply it. And while I believe a market should be considered as a resource, it should not be relied on, because what that does is it moves a great risk onto the customers, because they're going to have to pay those market costs. If they're stable cost, that's not so bad. But when they get real volatile, customers are at the whims of the market. So, you know, just like you shouldn't rely on wind, you shouldn't just rely on coal or natural gas, you shouldn't have a great reliance on the market, because that exposes customers to a great risk.
Okay. That's all the questions I have. Are there any recross based on questions from the bench, beginning with staff?
Kurt Stokes for staff, no questions, Your Honor.
For Liberty?
Yes, Judge, thank you. Just one issue. Judge Woodruff, I don't recall now the question he asked you, but your answer was about 2 purchase power agreements for wind that Liberty currently has. Do you recall that?
Yes, the Elk River and Meridian Way wind PPA purchase power agreements.
And you indicated that Liberty is losing money on those, but they keep the agreements in place. Do you recall that?
Yes, and I misspoke. Liberty isn't losing money on that. Its customers are paying an increased cost because of those.
Well, and actually, Ms. Mantle, although on one side, would you be surprised to hear, I guess, that on one side there's a $16 million loss, but then there's a positive $30 million in the market when you take TCRs into account?
Can you explain what TCRs, what are they?
Transmission cost revenues?
I'm not familiar with that. But it does get to the fact that there's a lot of things to be balanced and a lot of things to look at.
And also, as far as Liberty keeping those PPAs, they're locked in on contracts currently, correct?
I don't know.
All right, thank you. That's all I had, Judge.
All right, redirect.
Thank you, Nathan Williams for Public Counsel. Let's go to your table of resources on page 18 of your rebuttal testimony. Recall getting a series of questions about that?
Yes,
And you identified resources listed in that table as being dispatchable? You recall
yes,
that?
yes.
Are those dispatchable resources equally reliable in terms of being available for generating electricity? And if not, can you explain how they differ and why?
Well, nothing is 100% absolute. Coal plants, because they have their coal pile on site, they typically keep an inventory of coal, 30 to 60-day burn on site. Their fuel source is very reliable. The others, the combustion turbines, the combined cycles, plants take natural gas as necessary, and that source is fairly reliable on a normal basis, but it has also been shown during Storm Uri and then again in January of this year that fuel source is not always there when called upon. That would be the dispatchable resources.
Well, whenever you talk about the gas supply, is the gas supplied as it's used?
It is. There's no on-site. Well, the ones that have dual fuel does have fossil fuel or diesel fuel on site, but typically they prefer to run those on natural gas.
Well, you're talking CTs. We're just talking about the gas aspect of it. It's the fuel that's burned is used as it's received. There's not on-site storage, correct?
There's no on-site storage for the natural gas.
And there are some units that do have dual fuel capability where they can burn diesel or fuel oil, however you want to describe it.
There is some combustion turbines, yes.
And you've identified those already, I believe?
I'm pretty sure I got them right.
And they have a similar reliability as a coal plant, given that the fuel is on-site?
Yeah, and then they would have the other consideration of, especially the Riverton, the Kansas Health, and they have to get an air permit to run on fuel oil, but so there's different things for each type of plant.
And what about their generation capacity for a dual fuel plant versus a coal plant in Liberty's portfolio?
The dual fuel plants are a lot smaller. They're combustion turbines. Coal plants are typically large. The small ones are all being shut down. Where it has like EO-2022, 192, that's because that's a portion of the coal plant. State line you see Riverton and State Line combined cycles there. They're fairly large, but EO-10 and Plum Point are much larger plants than either one of those. It's just that Empire has a portion of those.
Now, there's also a hydro plant, is there not?
There is. Ozark is their hydro plant.
And how is it in terms of reliability of being able to dispatch?
If the headwater is there, they can dispatch it, and because the fuel cost is zero, it typically runs regardless of the demand because it can earn great revenue. It is very small. It's actually 4 megawatt units, and it's been there since the early 1900s. It's an old plant, but it has done well for Empire.
In response to, I believe it was questions from the bench, you talked, and maybe from Liberty, you talked about the market prices being 1,000 times what they normally were. How do those prices compare to the fuel used to generate power from coal?
From coal. The price of coal is pretty well set. I mean, it does not vary with the market.
But are we talking 1,000 times the price of coal, or? I'm trying to get at the difference between what the market price is and what the fuel price is in orders of magnitude.
I really can't say. Market prices are dollars per megawatt hour. Fuel costs are MMBTUs, but typically coal price is lower, much lower than market price. That's what makes them a plant that's run quite a bit, because the price, its variable cost is lower than the market price.
So in other words, if you were dispatching a coal plant into a market where the market prices were 1,000 times normal, you should be receiving all kinds of revenues from the market for that generation?
Yes.
Now, you got some questions about the white paper that's a schedule to your rebuttal testimony, I believe Schedule 2. You recall those?
Yes.
What did you rely on for creating that white paper?
I relied on my more than 30 years of experience in resource planning, some of which occurred before the arterial markets and some that's occurred afterwards. I've relied on resource plan filings. I relied on training received from Dr. Proctor 6 or 7 years ago on RTOs and the markets and how they work. Just relied on my experience working at OPC because most of my experience with RTOs has come after I started working at OPC. But and some of it's just common sense. That if you match your resources to your load, it's gonna be there when you need it, and markets run or you get your revenues on what is put into the market.
And I think one more topic. Do you recall you got some questions from staff about the Uri AAO, Storm Uri AAO that Liberty has pending?
Yes.
And there was reference to it seeking to recover the 5%. What 5% are we talking about? Is it all of the storm costs? Is it 5% of the extraordinary? Is it something else?
It's 5% of the, okay, it's not easy. They incurred fuel and purchase power cost, but there was some fuel and purchase power costs paid in base rates. So the fuel and purchase power costs then were net of what was put into what was recovered in base rates. I believe that was about 12 million. The total fuel and purchase was over 200 million. And it's 5% of what was left over after you take out what was paid in base rates from the total fuel cost.
No further questions of this witness at this time?
All right, thank you. Then, Ms. Mantle, you can step down. And that is our last witness for today. We'll resume at 8:30 tomorrow with, I believe we said Mr. Murray would be testifying first, and then we'd be going through Graves, Niehaus, and Davis. Yes. Okay. And then no one. Right. Okay. Thank you all very much. We're adjourned until tomorrow morning.
Thank you, Judge.